There we go. Okay. I'll call this first. Good morning. This is the New York City Board of Standards and Appeals review session for August 8th, 2022. No public testimony during the review section. Vice Chair.
Good morning. Thank you, Tony. I want to take this opportunity to introduce our newly appointed Commissioner Chris Yoon. Commissioner Yoon is a registered architect. She has worked in various architecture and development firms where she worked on a range of projects based in the city and elsewhere as a designer and project manager. I'm excited to have you on board and welcome to the board, Commissioner Yoon. I also want to take this opportunity to thank our outgoing chair, Pulmeter, for her leadership on the board for the last 8 years. So with that, welcome, Commissioner Yoon, and
Thank you. Thank you very much, Vice Chair Chanda.
Okay. So move on, Madam.
yes, please.
Okay. Review session. The following cases are adjourned. Item number 1, 66363BZ, 46 10th Street, Staten Island. Item number 2, 58482BZ, 200 East 64th Street, Manhattan. Item number 3, 18285BZ, 209 11 20th Street, Brooklyn. Item number 4, 18385BZ, 206. I'm sorry, did I do 18285BZ, 209 11 20th Street, Brooklyn? Item number 4, 18385BZ, 206-8 20th Street, Brooklyn. Item number 5, 29999BZ, 816 Malcolm X Boulevard, Brooklyn.
I want to just say something on this one, is that the applicant team will be undergoing a change in the membership. So we need to just be careful of the changes. Okay, go ahead.
I'm sorry.
No, I'm sorry.
Yes.
Go ahead, Carla, you're going to do it. Go ahead.
Yeah, so just to alert the board that in discussions with the outgoing applicant's representative, and hopefully this was conveyed to the applicant, obviously this application's had, this will be the third adjournment. So, understanding that we will give them a time to retain a new representative, but I caution that the property owner that this will be the last adjournment. And a dismissal warning is to be sent out, and that's just for the councils.
Yes. Thank you, Carlo. Beat me to it. Continuing with the adjournments, item number 6, 2021-16BZ, 302 West 128th Street, Manhattan. Item number 7, 2021-30BZ, 222 44th Street, Brooklyn. And for tomorrow's case, August 9th, which is item number 28, there's also an adjournment of 2020-86BZ, 15 Parkville Avenue, Brooklyn.
Madam Vice Chair, you're muted.
You're muted, Vice Chair.
Oh, sorry. So I want to say about item number 7, 2021 30BZ. This is also the third adjournment, and the council should send a dismissal warning letter to the owner and the applicant.
Okay, Vice Chair, could you speak a few minutes? I thought you bounced. You're losing your vote.
Can you hear me?
Very low.
It's a little muffled. Just move the laptop or something.
Okay.
Good. You're good.
Am I good now?
Right there. You're good there. Okay.
So what I wanted to say is that item number 7, this would be the third adjournment. So our council should send out a dismissal warning letter to the owner and the applicant.
Okay. Okay, and to repeat, item number 28, 2020-86BZ, 15 Parkville Avenue, Brooklyn, that is scheduled for tomorrow, August 9th, has also requested an adjournment. We will now move to decision items. Item number 8, 36049BZ, 6905 Elliott Avenue, Queens.
So the application was closed on May 9th, and the applicant was asked to revise the plans, amend the operational plan. We have received the submission, a revised plan, and that specifically in the revised plan, the applicant has the air and the vacuum tower will be relocated by a third-party contract, and the cloth bins have been removed, photos have been provided, and we have received the amended BP plan. A lighting study has been provided. I'm satisfied with the lumen analysis. I think in reality, achieving a 0.0 lumen at the property line is not feasible. So we are looking into it as to provide proper adequate. So I make a recommendation to approve this application with condition that the proposed improvements shall comply with the approved plan and shall be in compliance with the approved plan. All lighting sources that are located adjacent to residential use shall be shielded from direct view and to minimize any adverse effect on surrounding residences. The improvements shall be completed prior to the issuance of CO, and the CO shall be secured within 18 months. The condition should also include the relevant sections from the operational plan, and the resolution should be included in the resolution shall include the operational plan also. So with that,
Motion to grant.
motion to grant. Yes, thank you.
Vice Chair Chanda,
Aye.
Commissioner Otley Brown,
Aye.
Commissioner Shetta.
Aye.
Commissioner Shabeta,
Aye.
Commissioner Yoon.
I abstain.
Thank you. Item number, application's been granted. Item number 9, 808 55BZ 3504 Bell Boulevard, Queens.
Okay, so on this one, the application was closed on May 9th, and the application was closed on May 9th, and the applicant was asked to revise the plan to include noise attenuation. Just 1 second. Just give me a second.
Sure.
And the was asked to revise the include noise attenuation measures around the existing vacuum station, updating area lighting, and revising the operational plan. The applicant has tested the ambient noise and with the around the vacuum machine in operation, and the noise from the machine is minimal in comparison to the ambient reading. And the plans have been revised. Notes have been added to the plan regarding the noise attenuation and the details of the proposed 6-foot-high noise fence that would be placed around the vacuum tower. That has also been included in the plan. Notes regarding the reorienting the area lighting towards the parking area has also been provided, and that operational plan has been provided, clarifying the role of the site maintenance officer who visit the site once in a month. So with that, I make a recommendation to approve with condition that the proposed improvements, including but not limited to noise, lighting, and landscaping, shall be made in compliance with the approved plan. While a 0.0 lumen level at the property line is not feasible, the lighting level should be consistent with all the city regulations. All lighting sources that are located adjacent to residential use shall be shielded from direct view and to minimize any adverse effect on surrounding residences. The procedure will be reevaluated to provide we will look through the guidelines and we will try to update our procedures accordingly. Improvements shall be completed prior to the issuance of certificate of occupancy, and the CO shall be secured within 18 months, and the resolution shall also include the operational plan. So motion to grant.
Chair Vice Chair Chanda,
Aye.
Commissioner Otley Brown,
Aye.
Commissioner Sheta.
Aye.
Commissioner Sheta, can you repeat that, please? Your volume is not that good.
Aye.
Thank you, sir. Commissioner Shabeta,
Aye.
Commissioner Yoon.
I abstain.
Item number 10, the application is granted, sorry. Item number 10, 82755 BZ, 24520 139th Avenue, Queens.
Okay. This application was closed on July 18th. The only revision the applicant needed to provide was the revised operational plan, which has been provided. Again, similar conditions as to the previous one, approved with conditions that the proposed improvements to the site shall be made pursuant to the approved plan prior to the issuance of the certificate of occupancy, and that certificate of occupancy must be secured within 18 months of the issuance of the resolution. The other thing in this particular case, specifically for the future board, the resolution should state the following: that the distance, and this is regarding the location of the gas pump, distance from the pump island to the property was approved by fire department in 2016 as a pre-existing non-conforming condition under FP index number 1604010 dated 4/12/2016 as part of previous tank replacement. The resolution should also include the BP operational plan and alert that the future board needs to pay attention to the status of the trash enclosure at the site. Okay, I should adjust the screen. I'm being told I should adjust the screen. Is this better?
Yes.
Okay. The resolution should also include the operational plan and alert that the future board needs to pay attention to the status of the trash enclosure at the site, which the applicant has chosen to retain its rolling dumpster and not place it in an enclosure because the site is small and irregular. So motion to grant.
Vice Chair Chanda,
Aye.
Commissioner Otley Brown,
Aye.
Commissioner Sheta,
Aye.
Commissioner Shabeta,
Aye.
Commissioner Yoon.
I abstain.
Okay, application has been granted. Item number 11, 227-10BZ, 20412 Northern Boulevard, Queens.
Okay. This was closed on May 10th. The applicant was asked to do the planting, provide wheel stop, revise the operational plan, and the applicant also provided all the information, and with that, a video of the drainage, because that was a concern that the community had raised. So the applicant has provided a video of the drainage working, where it drains into the site and not off the site, and how it captures the drainage from the two cleaning towers. So the applicant has responded to all the comments, and so I recommend approving with conditions, making that the improvements to the site that be in compliance with the approved plan prior to the issuance of certificate of occupancy, and that the certificate of occupancy must be secured within 12 months. Though, and I said 12 months here because there's very little that needs to be done. It's really just the landscapings, and I think that we are in the season, so it can be done within 12 months. Though the lighting analysis did not raise any issues in this particular case, I just want, for consistency, add a language that that is consistent with some of the prior cases that I mentioned. That all lighting sources that are located adjacent to residential use shall be shielded from direct view and to minimize any adverse effect on surrounding residences. And also the resolution shall state the operational plan. So motion to grant.
Vice Chair Chanda,
Aye.
Commissioner Otley Brown,
Aye.
Commissioner Sheta.
Before I vote, I want to thank them for the drainage video. That was very helpful. And I believe we should add a condition that the drainage outlet or the drain should be maintained to make sure that no runoff comes from the station to the outside of the station. And again, thank you so much for being cooperative. Thank you. And I vote aye.
Commissioner Shabeta?
Aye, and I agree with the conditions set by both the Vice Chair and Commissioner Sheta.
Yeah, and I too agree with Commissioner Sheta's condition.
Commissioner Yoon?
I abstain.
And Commissioner, Vice Chair, again,
Sorry, I spoke out of turn. I spoke.
no,
out
no,
of
no,
turn.
not out of turn. I'm sorry, not to correct you. Your voice thing, your sounds.
Can you give me a second? I think I may have to put on a headphone. Just give me a second. Okay. Can you hear me now?
Yes. Sorry, I didn't mean to interrupt you.
Is it
before.
better?
Yes,
Can you hear me now?
yes. Can you hear us?
Yeah.
Okay. May I move, may I go on? May I go to the next case, Vice Chair? You ready?
Am I frozen?
No?
Okay. I didn't hear what you said, Tony.
No, I thought, is it okay if I go on?
Yes, please.
Okay. Item number 12, 2021, 24A, 155 Johnson Street, Staten Island.
All right. So I think on this one, we were waiting for a sign up from Fire Department and DEP, and we have received both. So I make a recommendation to approve with conditions. And the conditions are those that are stated in the DOB CCD1 approval. Those should be incorporated into our conditions and in our resolution. Motion to grant?
Vice Chair Chanda,
Aye.
Commissioner Otley Brown,
Aye.
Commissioner Sheta,
Aye.
Commissioner Shabeta.
Aye.
Commissioner Yoon.
I abstain.
Thank you. Application has been granted. Item number 13, 2018-26 BZ 7903 Roosevelt Avenue, Queens.
So on this one, there was no submission required, and this is a special permit with a term limit of 3 years. So motion to approve. And I just want to put a note, the resolution should refer to the operational plan
Right.
and also the provision of the off-street parking and on-site operation with regard to maintaining the crowd on the second floor, and that the second floor would be used strictly for waiting area.
Great. Motion to grant, Vice Chair Chanda,
Aye.
Commissioner Otley Brown,
Aye.
Commissioner Sheta,
Aye.
Commissioner Shabeta,
Aye.
Commissioner Yoon.
I abstain.
Okay, applications granted. We'll now go to SOC calendar compliance hearing, item number 14, 2019-27 BZ, 4533 18th Avenue, Brooklyn.
Hi, board. The board issued this February 22, 2021 variance resolution subject to an 18-month compliance check-in to demonstrate compliance with the board's condition. The applicant here makes a submission representing that they're in the process of compliance. Some conditions have been fulfilled. Some will be fulfilled upon completion of work under recently filed and obtained permits. Some conditions will no longer apply by virtue of code change or fire department waiver or minor modifications to plan. At this juncture, the applicant should be directed by the board to file a request for a letter of substantial compliance, and this compliance hearing may be closed. I would ask, however, that the board keep the compliance hearing closed but on the calendar, and the board may close this compliance hearing in contemplation of a complete approvable LSC application, at which time, upon notification to the board that our review under the LSC is complete, the compliance hearing may be withdrawn by issued resolution. Thank you.
Okay, thank you.
Okay,
So on the motion to close.
Yeah,
We can
not
make
a
the
review
motion to close
session.
in The hearing.
Oh,
not a review session.
Thanks, Tony.
Okay. Continued hearing items, item number 15, 6690 BZ.
Commissioner Sheta has his hand up.
Oh, I'm sorry. I apologize. I didn't see it. You're muted, Commissioner.
That's okay. Thank you, Tony. I just wanted to make sure that they indicated in their submission that a compliance has been achieved with the with regard to the structural integrity of the building. But the language in the submission wasn't like stating that clearly in like a clear language. So I just want them to confirm before us if they're going to be allowed to speak during the public hearing, that whatever work is done was satisfactory to the forensic engineering unit of the DOB, and they are satisfied with the structural stability of the building. Because what they said in their submission is they indicated that the FEU, the forensic engineering unit, was satisfied with the results of the probing. So this kind of language is not clearly indicating that DOB and its unit are okay with the stability of the building. I'm sure they did the right thing, but just wanted to put it in a language that makes it very clear. Thank you.
So the applicant's representative will not be present at the public hearing. He will, however, be listening to the board's comments, and these comments will be addressed through the LSC process, at which time we will be collecting evidence of compliance.
Sure.
Okay,
Thank you.
thank you.
Okay, I don't, we'll move on.
Yes, please.
Okay,
General Counsel's hand is up. Do you want to add
Tracy, you
anything?
still up? Okay.
Okay, all right, let's move on.
Continued hearing items, item number 15, 6690 BZ, 4303 Astoria Boulevard, Queens.
Did I freeze or did? Okay, all right.
No.
Because for a brief second, there was like a freeze. All right, so the application was last heard on March 28. At the last hearing, the board had asked for clarification and the applicant has submitted its response. Applicant has provided photos of the improvements made. Asphalt paving has been completed, shields added to the light fixture located along the eastern lot line, and landscaping has been installed at the corner and along the eastern lot line. So from the photos that were submitted, photo number 12, it seems shields were also added to the third light fixture from the street. So I would like the applicant to confirm, and if so, it's great that they're doing this initiative without us being asked. But the applicant just should add a similar note to the plan as has been done on drawing C001 note number 5. Also, photo number 12 shows additional banners that are mounted on the 2 light poles. These should be removed because otherwise the signage exceeds the maximum permitted along 43rd Road. So to that, a note should be added to the plan that the signage shall comply with C1 signage regulations, and it is for DOB to review and approve the signage regulation that the site conforms, complies with the signage regulations. Also, photos 15 and 16 show that the landscaping along the northern lot line is in poor condition. I'm assuming that is the area where the trash enclosure is going to be built, and so for that reason, it has not been done. So as and when the trash enclosure is built, the landscaping along that edge should be addressed and fixed. Fence along the eastern lot line is in good condition, as shown in the photos. The applicant has revised the plans. The lumen study has been provided, and I really don't have any additional comments on it. The concern was lighting from the subject side affecting the rear yard. And based on the lumen, measured lumen study, it's at 0, but as I mentioned, I think reality of achieving 0, it's difficult, but if they can achieve it, that's great. But I think we should add a note for the time being until we come up with a clearer standard that all lighting sources that are located adjacent to residential use shall be shielded from direct view and to minimize any adverse effect on surrounding residences. And should the abutting residence uses express any concern regarding the lumen spread, then the applicant should address those concerns. So those are my comments. Commissioner Otley-Brown.
I agree with you, Vice Chair, that we should have a few of those different requirements listed as conditions in the grant. And I'm referring to the lumens and the reduction of light spill at the residential lot lines, as well as to have the signage validated and verified by Department of Buildings. I myself have no additional comments.
Thank you. Commissioner Shetta.
Thank you, Vice Chair. Yeah, I want to praise this specific applicant. I have noticed for probably the 4th hearing in a row that cases from this applicant is getting like to the finish line very quickly. Their submissions have been like very responsive to us. On this case, the luminous spread looks fine. The foot candles at the residential lot line is between 0 and 0.5 foot candles. I believe that should be okay. And they responded to the other comments that we raised during the last hearing, and I'm ready to close this case if everybody's okay with that. Thank you.
Thank you. Commissioner Shibata.
Thank you, Chair. I found this quite responsive. I agree with the comments that you made. I asked that, and I'd be prepared to close upon them stating that they would make the improvements that you requested.
Okay, great. Thank you. Okay.
Commissioner Yoon.
Yoon, Commissioner Yoon.
Oh, sorry, Commissioner Yoon.
That's all right.
My apologies.
No problem. I anyway abstain from making any comment on this case.
Okay.
Item number 16, 12992 BZ, 15055 Cross Island Parkway, Queens.
Okay. So this application was last heard on Jan 10th. The applicant had submitted the documents in response to the comments raised at the last hearing. Specifically, first of all, we also received actually 3 letters of support. One from the residents abutting those homes along Clintonville, and 2 are from the adjacent commercial occupants, the Northeast District Council of OPCMIA and the Whitestone Properties Association. These two commercial uses, they abut the rear and the side lot line of the subject site. And no one objected to the existing metal fence, and also had no issues with the operational plan, including noise and lighting. I think OPCMIA went one step further and said that the metal fence is mutually beneficial to them, as it also protects their site. So at the last hearing, the board had directed the applicant to submit ZRD1 plan with photos, and this was reviewed by our office, by our general counsel before it was sent to DOB. And as part of the CRD1, the applicant has made some revisions to the canopy structure. And this is specifically with regards to how much of the perimeter can be enclosed without it be counted towards floor area. So to ensure that no more than 50% of the perimeter is enclosed, the applicant is proposing to reduce the corrugated metal fence along the rear and the side lot line. And those have been reflected in the drawings, and a perimeter wall analysis has also been provided showing that the proposed changes would be in compliance with the floor area definition. So I do not have any issues with keeping the existing corrugated metal fence as long as it is not rusted and falling apart and tearing. It really needs to be maintained in good condition. And I hope the neighbors will keep an eye on it and alert them, because a corrugated metal fence tearing off and flying off can be very dangerous. So I want to make sure everybody is aware of it and is being careful and taking good care of that structure. Regarding the lumen spread, the lights are positioned downwards and is located 85 feet from the adjacent residential homes that are located along Clintonville. The board also received a letter, as I mentioned, from the abutting residential building on lot 110. And the applicant did not raise any concerns with regards to the lighting. So as I had iterated in the earlier hearings, I do not believe a lumen study at this site is necessary because of the location of the site in relation to the abutting residential homes, which are at a much higher elevation. And there is a distance of over, I thought it was 70 feet, but the applicant is stating 85 feet. So I'm quite satisfied with it. But again, to be consistent, a note should be added to the plan, and that should be part of the condition, that all lighting sources that are located adjacent to residential use shall be shielded from direct view and to minimize any adverse effects on surrounding residences. Regarding no noise sign, the applicant has provided that sign as we had asked the applicant to provide. And it states that the drivers have to lower the noise level, no honking and such. So I'm overall satisfied with the changes the applicant has proposed. Of course, we need the ZRD determination. So with that, Commissioner Otley-Brown.
So I was one of the commissioners who had originally raised concern about the appearance of the corrugated fence to the neighbors. And I have to say that I am now satisfied with accepting the corrugated fence because they have reached out to the surrounding neighbors, and the surrounding neighbors have assured us that they don't consider this a problem in any way, shape, or form. And so given that, I actually don't have any more comments on this case. I'm willing to let the DOB opine on whether or not it's actually floor area. And once we get that answer, I'm fine with you closing the case if you so wish to.
Okay, thank you. Commissioner Sheta.
Thank you, Vice Chair. Yeah, regarding, I start with the lumen spread. During the past hearing, I had a position that like the lighting, all the lighting is pointing downward. The elevation where the lighting were installed was like not that high from the grades at the adjacent property. So the chance of these lighting units shedding light on the adjacent residential wasn't almost not existing. With the submission they made this time, I'm satisfied with the lumen spread. I didn't change my position since the last hearing. That regarding the corrugated metal, I see in their submission that they are asking for a legalization of a floor area. So I'm not sure. I was a little bit confused. Is this gonna be like their request based on the outcome of the ZRD? If the ZRD comes back with DOB confirming that cannabis is a floor area, are they intending to like keep this request, the legalization request, put it before us? And if so, do they need to file an amendment? I'm not sure. I was confused on that. But
So, go ahead.
if
Finish it.
we're gonna take the corrugated metal like wall on the perimeter, I'm fine with it since the neighbors are okay with it. I'm not taking, or this board is not taking any position on the stability of this wall or even the compliance of this wall with the requirements of the building code. This is not our job. It should be looked at somewhere else. I believe it's DOB concern. And yeah, I believe the case now is ready to move on and close it.
I see our executive director's hand up. Is this regarding what I was going to say about why the ZRD one has been submitted?
No, I was just going to address Commissioner
Amendment.
Sheeta's procedural question regarding in the event that the ZRD1 determines that this is floor area and there's a path for them to try to legalize it here, Dr. Sheeta is correct. They would need to file an amendment at that time, and we would need the DOB objection. Obviously, the ZRD1 would serve as that.
Yes.
But just as a matter of just procedural clarity. But again, I'm assuming the applicant can address the timetable that they need, tentatively to get the ZRD1, and then I'm available to assist them in any way to procedurally give them guidance.
Right. Commissioner Shetan?
Yeah, thank you, Vice Chair. Thank you, Carlo, for the clarification. Two more things. I would urge the applicants to please focus on what's being said during the hearings, because in this submission, I've seen two things. The first thing was that the board asked for a luminous spread study. It didn't happen. All what was said is there is concern that some light shed to the residential could happen. And what we did ask for is just one reading next to the fence. We didn't ask for a study. The second thing in the cover letter, I saw at the very end of the letter, there is a response to a comment that I actually didn't raise regarding a retaining wall key. I wouldn't ask for a key for a retaining wall that's been installed years ago. So we didn't raise a concern about the retaining wall during the last hearing, nor about the key. I just wanted to clarify this because it's in the submission.
So are you suggesting that be removed from the submission? Commissioner Shetan?
I'm sorry, can you repeat? I can't hear you well.
So Commissioner Shetan, are you suggesting that key, the retaining wall key, be removed from the submission?
There is a key already on the drawing, but my point, when you ask for a key installation, that means that you're still building the wall and somebody's giving you a detail without a key, and you say, hey, you cannot install this retaining wall as shown, please show a key. But the key, that the retaining wall itself is there. It's been installed long time ago. So if somebody like reads this and he's gonna like think that we already asked for a key for an existing retaining wall, that wouldn't be like.
So I'm not very sure if prior board had had the retaining wall specifications in the drawings and it has been carried forth. Maybe the applicant can clarify that at the hearing. If it is something that the prior board had requested and that's why it's on the drawings, the applicant should clarify that. If it was never asked by the prior board, I'm not sure why we should have it, honestly speaking. So the applicant can clarify that. And thank you, Carlo, for clarifying the procedural part of it with regards to floor area. So yeah, we cannot, even though we seem to have a consent, I mean, I haven't heard from Commissioner Yoon, but I think we have to wait until we get the CRD1 to take the next step. Commissioner Yoon?
Commissioner
Well, how about-
Shabeta.
Oh, sorry, I'm so sorry, Commissioner Shabeta. My
Thank you, Chair.
apologies.
Thank you. So I have some similar comments. I'm now satisfied with the fencing. I was happy to see the sign with regard to noise and music. I think we could use this one as a sample. And I'm glad to hear that they did finally file the ZRD1. And I wait to see the returns. I'm not going to opine now as to whether or not we have to wait. But I think those are my comments for now.
Okay. All right. And Commissioner Yoon.
I don't have any comments at this time.
Thank you. I think we do have to wait and see where the ZRD1 lands. Because if it requires modifications to the plans,
Could it be a letter of substantial compliance? No.
we could, but let's discuss that at the public hearing. I'm a little uncomfortable doing it because if as submitted, that is acceptable to DOB, then there's nothing we have to do. We just kind of go with it. If, however, what has been submitted still results in floor area, it's not a substantial compliance because it's an amendment, it's an additional floor area.
Right.
So then we can reopen it. If we do decide to close it during public hearing, we'll have to reopen it and go through an amendment. So let's discuss it during the public review. I think it's a little early. Commissioner Brown, you were going to say something?
I was just going to second what you said because it is a variance. And so like you said, if there is additional floor area, then that might mean that the findings are impacted. So it would require further examination.
Yeah. Okay. All right. Thank you. Next case, please. Thank you all.
Item number 17, 21406BZ, 19625 Hillside Avenue, Queens.
Okay. So we have received the community board vote. The committee board has voted to approve this unanimously. This application had its initial hearing on April 26th, and at that hearing, the applicant has proposed to improve the site conditions by landscaping it and revise and making all the improvements. I'm extremely satisfied with all the improvements the applicant has done. And keep in mind, this was done without the applicant providing the drawing. So they followed all our guidelines to the T, I would say, based on all the improvements that they have taken and have submitted the revised plan accordingly. In-ground planting looks good. They have put a wheel stop, not a wheel stop, many wheel stops. Excess banners have been removed. Handicap access area has been marked, dimensioned also. So I want to thank the applicant for making these changes and really fast tracking this project. So thank you very much. Again, on this one, we never raised the issue of lighting, but again, just for consistency, just add a note stating that all lighting sources, and I don't want the drawings to be revised. We can put this as in the resolution as a condition, that all lighting sources that are located on the lot line adjacent to residential uses shall be shielded from direct view and to minimize any adverse effect on surrounding residences. And also based on the community board meeting minutes, it seems the community board recommended that the board put a condition that no parking on sidewalk. So we can also put that as a condition. But that's my recommendation. Commissioner Brown.
I'm satisfied with this application and have no questions.
Thank you. Commissioner Shetta.
Thank you, Vice Chair. Again, this is one of the responsive submissions. Another good one. Thank you to the applicant, and I have nothing further to add. Thank you.
Thank you. Commissioner Shabeta.
I'm satisfied with this application. I am glad to see all the improvements that were requested were made. I have nothing further to add.
Thank you. Commissioner Yoon.
I have no comments at this time.
Okay. Right, next case, please.
Excuse me, there's a squeaking noise. Is that you, Vice Chair, or somebody
Is
else?
that me?
Somebody's squeaking. So
I
could you
believe it's
mute
one-
yourselves if you are not participating? Could you mute yourselves? Thank you.
I believe it's when Vice Chair Schaefer types, you hear that noise.
Oh,
Oh.
okay. Okay.
Oh boy, am I that much of a loud typer?
It's okay,
Sorry
Vice
about
Chair.
that.
We'll ignore that then. I just want to make sure we're not doing it. Okay, sorry. SOC calendar, new cases, item number 18, 33790BZ, 1415-17 East 92nd Street, Brooklyn.
Okay, just give me a second. I just want to pull out the things. All right, so we have received proof of service for initial filing and hearing. Community Board has approved this application. This is an extension of term for 10 years of a prior use variance pursuant to zoning resolution 11-411 for continued operation of a one-story automotive repair establishment. Now, per zoning resolution 11-41, lot area of the zoning occupied by such use has to have remained same based on the 1950 resolution.
Vice Chair, you're frozen.
Yeah, let's just give her a second.
Okay.
She's frozen.
Can you hear me?
Yes,
Do I have to
ma'am.
repeat?
We lost
Yes,
you.
please,
Under the-
Please repeat what you say. I'm sorry. Too
Yeah,
many-
can we, one person at a time, please? Madam Vice Chair, just repeat your statement. You did freeze there momentarily.
So should I start from the beginning?
Yes, just for clarity.
Okay. We have received proof of service for initial filing and hearing. Community Board approved this application. The action before us is an extension of term for 10 years for a prior use variance pursuant to zoning resolution section 11-411 for continued operation of a one-story automotive repair establishment. Now, per zoning resolution 11- lot area of the zoning occupied by such use has to have remained same based on the resolution and the existing site plan. So the applicant should clarify that during the hearing and also revise the statement. Yes, Carlo, do you have?
Yes, I'm sorry. I just wanted to clarify because the project description I'm looking at has it permitted an automotive repair establishment use group 16B and a two-story mixed-use building with retail use group 6 and residential.
Right, but the
The action before us is for the automotive service station.
Exactly.
Repair shop.
Yes,
I
thank you
just
for
wanted
that.
to clarify that for the record. Thank you.
Yes, thank you. Yes, so there are three uses on the side of that, the residential and the commercial uses as of right. So what we are reviewing, just the automotive repair, the one-story structure. Thank you, our executive director, who is always listening in and alert. Thank you. So this is a corner site. It has two buildings. We are only focusing on one building, which is the existing one-story building used for automotive service facility. It has an accessory parking space, which is used for vehicles awaiting services. There are two curb cuts. It's not clear from the curb cuts, especially the curb cut on 92nd Street, if it's a shared driveway with the abutting residential use. So I want the applicant to clarify that. And the reason for that is who then maintains that curb cut is really the question that I want to be answered. So the applicant provided the compliance chart for 2012. I looked through the prior conditions, conditions from 1992 to 2012, and it seems all the conditions are same, except that in 1992, as part of the change of use from auto service station to auto repair, a negative declaration was issued where DEP had required groundwater sampling to be determined. And I believe in 2009, the prior board had ensured compliance with DEP. So that has been addressed. So I was okay with what has been submitted. Now the zoning district designation on the zoning chart is incorrect. It should be R5D with the C13 overlay. So the hours of operations, there was a condition as part of the prior grant. The current hours of operations is well within the permitted hours that was granted. So most of my comments on this site is with regards to the site condition. One of the condition was that there be no parking on sidewalk, and the site photos provided show that there are vehicles parked on the sidewalk, mostly along Avenue L. The applicant must provide an operational plan. And what I want to know is who is responsible for monitoring the no parking on sidewalk? Is it the owner? Is it the operator? Or is it both? The sidewalk along Avenue L is a very wide sidewalk, and some of the buildings that are abutting the subject site, their yard kind of extend into the side yard. So maybe that is kind of giving a kind of a misunderstanding and a cue as to where the property line is. So I think two things needs to be done. The applicant should put a sign on the Avenue L frontage saying no parking on sidewalk, and also to ensure that the vehicles are parked within the parking area, within the subject lot. Place bollards with chains to contain the vehicles parked for repair within the site. And also this would clearly demarcate the boundaries of the parking area abutting the sidewalk. So, and also from the Google Street View map and the aerial, it is evident, and the photos that's been provided by the applicant, there are more vehicles parked on the site than 5 spaces as shown in the drawings. I want to know how these vehicles are maneuvered. The reason for asking that question is that it should not result in too much of encroachment and conflict with pedestrian movement along 92nd and Avenue L. So that is why I'm asking that question. And the other part is that if it is possible to provide more parking spaces on the site, indicate that on the plan, provided you can maneuver it as much within the site without having to obstruct the pedestrian sidewalk. I also, and because of all the movement, it has affected some of the sidewalk conditions. So those should be cleaned up. I would ask our compliance officer to visit the site and also in future make periodic site visits of this site. With regards to the light, the applicant states that the business, after business hours, the lights are turned off. There are no outdoor lights in the evening. Great. And I think the applicant should put a note still. If in future any lighting is to be put, it's a similar language that I've been mentioning in today, that should be added in the plan in case any future lighting is placed. With regards to trash enclosure, with regards to trash, there is a trash bin located on the property, and this is abutting the residential home. However, this home has a driveway that is separating the residential home itself physically from the property. the subject property. So I haven't seen any perimeter site photos. The applicant should provide that. And based on the Google Street View, it seems there are excess material stored along that residential property line, including tires and other material. We do not support tires being located outside, if only during business hours. Given this site is so small, I think that is the extent we can allow it, but after business hours, they should be stored inside. But the applicant should provide photos of that. I don't have any other comments as current anymore. Commissioner Brown.
Yes, hi. My only concern with this case is the cars that were actually photographed, parked on the sidewalk on Avenue L. And as you also requested, I would like the applicant to address it and provide a plan to monitor the situation so that it's eliminated.
Thank you. Commissioner Shetta.
Thank you, Vice Chair. The first point I want to address is that in the submission, the statement of facts indicates that the auto repair shop has now has an access to the cellar of the building. I'm asking them to clarify about the access. What is the reason for providing such access? Is it from inside the shop? Is it from outside, like the one that access that's shown on the plans? And if it's different, were there any modifications made to the plans? I haven't seen any modifications on the previously nor the existing plans. The other thing is, yes, I totally agree that the site conditions are horrible.
I'm sorry, I think I'm freezing. I think I froze because I didn't hear anything what you stated, Commissioner Shetta.
Let me. You want me to repeat it, Vice Chair?
Yes, please. Yes.
Sure. The first comment is regarding what is called an access for the auto repair to the cellar.
Mhm.
I would like to know what is the reason for providing that access to the cellar for the auto repair, and how this access was secured, whether it was any modifications to the plan, to the existing structures, any deviations from the previously approved plans. They need to provide us with clarifications on that. The other point is regarding the operation. I did look at the site, and I believe that the site is in like very bad shape when it comes to operation. That there are cars parking on the sidewalk, yes. Even there are cars being repaired on street, on Avenue L. There is a car with the hood open. If you look at the Google images, if you count the cars parking on site, they are way more than, probably it's 2 times the 5 parking spots. So they need to clarify to us how they are handling moving these cars around. With regard to the lumen, they indicated that no lighting is installed outside. Yes, I agree that if no lighting is installed outside, they don't need to worry about submitting a lumen spread study. We don't need that. And hopefully this is gonna stay the case. And other than that, also the noise, I'm sorry, the noise to the neighbors. I'm not sure if cars being repaired on site, outside the shop. I did look at the resolution, and the previous resolution indicate that if you want to repair cars, you need to do it inside the shop. Now cars are not just repaired outside, but they are repaired on street. So if with that activity being on site, whether I would like them to like educate us, whether there are any complaints about noise from the adjacent residential. Thank you.
Okay, thank you. Commissioner Shetta.
Thank you, Chair. I have a lot of similar comments. I do, I don't want to be repetitive. I do want to add that I did notice that there is a vehicle, an X5, that doesn't have a license plate. on, and I was just want the applicant to speak towards that. Are they selling vehicles? That's not within the resolution. I just wanted to be addressed.
Thank
Nothing
you.
further.
Okay. Commissioner Yoon?
I have no comments at this time.
So, yeah, I also actually, going back to the comments Commissioner Shetter has, yes, I did also from the photos notice there were cars with the hoods open, but sometimes I've noticed they are open because they're trying to cool the machine, but not necessarily doing the work. My biggest concern is that there shouldn't be any work going on outside the building, which from the photos provided, not seeing anybody working on any of the machines and on the site and on those vehicles that are parked by the sidewalk or also by the curb. It's not clear, but the applicant should clarify that and state it in its operational plan, how they operate and how the vehicles parked on the site, what are they used for? Are they used for storing of vehicles to be repaired, or as Commissioner Shigata said, is it being used also for used car sale? Because that is not permitted, and that was not permitted as part of the prior grant. So we have a lot of questions, so the applicant should come prepared to respond to these questions. Okay, next question, next item, please. I can't hear you, Ms. Matias. You're
Sorry, I'm muted because there's a little bit of noise back here. Item number 19, 2016-4176BZ, 7804 31st Avenue, Queens.
okay. For extension of time, proof of initial service and hearing is not required. This is an application for an extension of time to complete construction and to extend the time to obtain certificate of occupancy for an additional 24 months to complete the construction of a 3-story plus cellar house of worship that is underway, located in an R4 district. Prior grant required that the certificate of occupancy be obtained by October 3rd, 2021. In 2017, the board had granted a bulk variance to modify the front and side yard requirements with conditions for this subject corner lot site. And one of those conditions is that the CO be obtained by October 3rd, 2021. I just want to bring to everybody's attention that the board history is incorrect. It states that it was a special permit. It's actually a variance. And also board had approved a 3-story plus a cellar building. And from the photos provided, the cellar seems to be complete. And but that reference is missing throughout the statement of facts. So our resolution should correct that. And the recent site photos that's been provided from the August submission, I think which was provided this Friday. The structure seems to be complete. Much of the interior work is complete. And primarily what remains is to obtain a TCO for the, so that's good. But I would like the applicant to clarify the delay in obtaining the TCO. I'm assuming that is primarily because of the city's moratorium on non-residential construction during the pandemic and followed by the supply chain issue. So the applicant should clarify that. And the applicant states that it would need about 6 to 9 months to complete, to get a TCO. And there aren't any open violations, so I'm okay with the application. Commissioner Otley-Brown?
I do not have any questions for this application. I feel that they were pretty clear in talking about both their delay, the amount of work that was complete, as well as a timeline telling us exactly how much time it would take to complete and get the TCO, as well as what work remains to be done.
Thank you. Commissioner Shetta?
Thank you, Vice Chair. I agree with Commissioner Brown. Yes, the submission was very clear and satisfactory, and I have nothing further to add. Thank you.
Thank you. Commissioner Shetta?
Thank you, Chair. I agree with your comments. I have nothing further to add.
Commissioner Yoon?
I have no comments at this time.
Thank you. Next case, please.
Appeals calendar, continued hearing item number 20. 2020-58A, 2020-59A is 1012 Jasmine Way, Staten Island.
All right. So the initial hearing was held in March of 2022. The only outstanding issue was a DEB sign off, and a DOB had asked for FDNY approval of the BPP and cross driveway easement. We did receive a draft of the cross driveway easement between parcel A and B that was submitted in July. The applicant has submitted its application for review and approval to Fire Department, Bureau of Operation. It was submitted in May. And so once we have the Fire Department's approval, it should respond to the DEB comments and DOB comments. I have nothing to say at this point. Commissioner Otley-Brown?
I have no comments.
Okay. Commissioner Shibata? Commissioner Shetta.
That's okay. Thank you, Vice Chair. Same here. I have nothing further.
Commissioner Shibata.
Thank you, Chair. I reviewed the easement. I found it to be satisfactory, and I have no further comments.
Thank you. And Commissioner Yoon.
I have no comments.
Just give me a second. Okay, next case, please.
Okay, do you want me to call the vesting and the BZY separately, Madam Vice Chair?
Yes, please. No, call them together. Though I will go back and forth. It's easier to go back and forth, but I will keep referring to both of them. Carlo, our executive director has his hands up.
I would separate them out.
I would separate them out because they're a different set of findings. I mean, obviously we're looking at the statutory first, and then we'll fall back on the.
Well, the vesting is first.
I think the common law is first. Okay, fine. Let's go with two separately. That's fine.
Okay, so item number 21 is 2021-79A. This is 3860 11th Street, Queens. This is a common law vesting application.
Okay. We have received proof of service for initial filing and public hearing. The committee board has waived its to hear this application. This is an application seeking common law vesting to renew the building permit that was lawfully issued before December 2018. That required a special permit for the development of a 9-story transient hotel in an M that otherwise would have required a special permit for a development of a 9-story transient hotel in an M13 district post December 2018. DOB confirmed that the building permit was lawfully issued. It was issued on June 7, 2016. The application is filed in tandem with 2021-81 BZY, which is for statutory vesting. We will discuss that a little bit later. But the subject application is a common law doctrine, which is articulated in the Putnam Armonk v. Town of Southeast, and also and in the case of common law vesting, Putnam Armonk requires a substantial expenditure, substantial construction. Let me go back. In the case of common law vesting, Putnam Armonk requires that substantial expenditure and substantial construction occurred prior to the date of the text amendment, which in this case would be December 2018, and that made use group 5 hotel not an as-of-right use in an M zone, and that the absence of vesting relief, the owner will suffer serious loss. Uh, So with regards to the common law vesting, as I mentioned, substantial construction and expenditure has to be shown. The applicant has been, sorry. With regards to common law vesting, the applicant needs to show that substantial cost and expenditure has been made prior to the enactment date of December 2018. Applicant states that 100% of the foundation was completed, as was 5% of stucco and cinder block, 5% of steel structure and decking work, 1% of electrical wiring, 1% of plumbing, prior to the enactment date of the text amendment. However, I did not see any progress photos on file that could clarify as to when these these were completed prior to the enactment date. So the applicant needs to provide those documents and proof that 100% of the foundation was completed prior to the enactment date. And as were these other tasks identified. With regards to substantial expenditure incurred and spent, the applicant has provided a detailed financial expenditure made to date. Now, according to the document, $3.1 million has been expended to date. And of that, 2.4 million was expended prior to the effective date of the text amendment. And the total estimated cost of the project is 5 million. The applicant needs to show the expenses made prior to the effective date of the text amendment. This 2.4 million seems to include real estate taxes. It also includes snow removal. I don't think they should be included. It is difficult to determine the expenditure that has been made prior to the text amendment from this though detailed expense list that has been provided. And I appreciate the applicant providing this with the breakdown by each vendor, but it was difficult to kind of follow it and identify how much was expended prior to the text amendment. So the applicant needs to revise the cost analysis, remove the amounts that should not be factored in, like the real estate cost and such, and also highlight the costs that are specifically related to common law, which is money spent before the enactment date. Another aspect of the common law vesting is that there would be serious loss if the owner was denied the right to proceed. The applicant states that to allow a hotel construction in an M13 district, a special permit from City Planning Commission would be required. And also an as-of-right development pursuant to an M13 would require a demolition of the existing structure and foundation, and would have to remove, and these would have to be removed to accommodate as-of-right use, including mechanical, plumbing, and electrical work, and there's an associated cost with it, which is $900K, the applicant claims. Another point to note with regards to this site, it's a 25-foot wide site, about 2,400 square foot lot, so it's a rather small lot for a manufacturing use. And we have seen such cases before variants. They're not quite so, I'm just kind of pointing that out. And the construction that is underway is based on an alternate required height and setback regulation, where the building is set back 15 feet from the lot line, and then it has a sky exposure plane of 3.7 to 1. Whereas if an as-of-right development like a manufacturing or an office use were to be built, it would typically want a larger footprint, and that would be applying a standard height and setback. So this would result in revising the drawings and others too. So I think my way of saying all of this is to say that there would be serious loss if the owner were denied the right to proceed. However, the applicant also needs to demonstrate as part of the common law vesting that there has been no abandonment of rights, which the applicant kind of shows it but doesn't state it. And that is that there were several construction and site safety related violations that were issued by DOB. And it seems from DOB's submission that most of them have been resolved and they have been deliberated. It's just paying the certificate of correctness and other things. So this goes to showing that the fact that the applicant is working actively in addressing all the violations shows that there has not been an abandonment in this case, but the applicant didn't quite state it in its statement. So that should be clearly stated. However, I'm not quite sure the applicant can meet the first set of finding, which is when was the construction completed prior to the enactment date, because I don't have those documents, the photograph, the progress photographs to help me kind of clarify that. So that's my comment on it. Should we go? Sorry.
They owe $20,000 worth of fines, just
Right.
to raise that. Also, I wanted to mention, and I'm sure, I don't mean to talk out of turn, Commissioner Otley Brown will mention, there's an acquisition cost that I realized was included in the cost, which I don't believe we allow.
Okay. Okay, thank you. Thank you for bringing that to my attention. Okay, Commissioner Otley Brown.
Yes, hi, I have a few questions about this case. As to the substantial construction before December 20th, 2018, the text amendment date, the statement says that all of the work was complete as of the text amendment date. However, if you look at the Ganesh affidavit, it says the work was completed as of today. So they need to clarify what actually was done by the text amendment date. And I agree with you, Vice Chair, that that can be done with photos, dated photographs. As for the substantial expenditures by December 20th, 2018, they talk about the total of 3.137 million, but as both you and also Ms. Matias has stated, that does include items that are not usually considered in this vesting, and they need to remove those items. But also what they really need to do is separate the items out into pre-text amendment date and post-text amendment date, so we can be clear what was actually expended and also what was actually incurred but not yet expended, and that would be helpful. As for serious loss, it might be instinctive that they have a serious loss, but I might have been looking at the wrong information. They, to me, did not detail whether or not the foundation and the 2 floors could be repurposed for a conforming project. And they also didn't really address whether or not there would be reduced income projected for a conforming project. So a lot of what they said to me were generalizations, and I would prefer if they specifically stated, for instance, if we cannot proceed unless we get a text amendment, a lot of the applicants have said that would lead to a delay in us completing the project, which would be a delay in us having an income producing project, resulting in a loss of so-and-so. And in addition, the rents that we could get for a conforming project are much less than the rents that we could get for the proposed project that we have here. And then also address, we spent this amount of money on the foundation and superstructure, and oftentimes they support this with actually a foundation drawing and a superstructure drawing that shows that if we have to proceed as of right on a project under the new zoning, which would probably be industrial or office building, we can't use these parts of the existing structure. And so that would have to be demolished, redesigned, and rebuilt, and put a cost on that as well. So I find that any detail that they can provide as to serious loss makes their case that much stronger.
Okay, thank you. Thank you for that is very helpful. Thank you. Commissioner Shetta.
Thank you, Vice Chair. I did look at the submission, and I do believe that they have submitted, the only document that has been submitted that indicates the foundations and excavation support were complete before or on the effective date was a TR form that was signed and sealed by the engineer. That TR form like indicates that the initial work is done, the initial investigation is done, and then for the SOE and the foundation, it indicates that it is complete. I agree that we need some pictures, some photos, probably some field inspection reports to like justify that point. What I don't like in the submission is, and let me, I'm not sure how to visualize this, but I would say if you have a lizard trying to sneak into your window, you don't have to use a machine gun to stop. And this is something that they are almost done. In the submission, it says if the applicant had to comply with the zoning changes, the building would have to be demolished and the foundation would have to be removed to accommodate the different use. No structural engineer, I would say, would accept this kind of very broad statement in a submission like this. Of course, if you do have a foundation system in place, you can use it for residential, or you can use it for like a hotel, or you can use it for a hospital. The idea here is not, you don't need to knock down the entire foundation system. You need to repurpose that. And what I was looking for is a sentence or two to explain to us that repurposing these foundations and whatever else, the skeleton, the steel structural skeleton, is gonna take time, money, and probably some partial demolition. But it's not total demolition. This sentence in the submission puts me as an engineer on this board in the corner. If I accept this and I say, yeah, I'm fine with it, that wouldn't be like good for me. So I would like them to just please mitigate your language. Yes, I buy it. If you need to like change the use, it's gonna be some changes, probably to the foundation and to the skeleton and probably to the electrical and plumbing. Agreed. But make the language some sort of softer. It's not gonna be total knockdown of the building. It's not gonna be total demolition. In my opinion, even if you look at the foundation and do a redesign, for me, this is a headache, this is a loss, this could be considered by this board. And I believe it was considered before as an item to like look at when granting these kind of applications. But please, no like aggressive language like that. I'm very sensitive to these statements. So I hope they revise this, that the applicant would need to knock down the entire building. I don't think this is needed. The applicant would need to remove the foundation and knock him down, replace him. I don't think this is needed.
I have to apologize. Maybe it's me who is freezing up because I didn't hear a little bit of Commissioner Shetta's statement towards the end, but I think the gist of what Commissioner Shetta said is that the language is very general and it needs to be more specific to the site. Hello, am I the only person who's frozen?
You're not frozen.
Okay.
You're not frozen.
Okay, because my screen is freezing up, so I'm not sure. Okay.
Madam Vice Chair, you're fine on our end. I mean, you have been glitching all day, but you're fine right now.
Okay, so my apologies. I missed the last bit of Commissioner Shetta's, but I think what Commissioner Shetta is saying is that the statement as provided with regards to substantial loss is very general, has to be more specific to the site and talk through the details as to what is the cost and the time and demolition that would go into in making the structure repurposed for as a right use. Is it in a nutshell? Am I correct?
I wouldn't say it's very general. I would say it's very untrue. That the foundation system, again, does not need to be knocked down, removed entirely. Yes, it's gonna need redesign. Yes, it might need some partial demolition. I haven't looked at structural drawings and I don't need to. Once I know that there is a foundation system in place, it's like 1, 2, 3 for me. Yes, it's gonna need some partial redesign. It's gonna need probably some partial demolition. Same thing for the structural system, for the structural steel skeleton. They don't need to mention anything beyond that. But to put a statement saying that they need to knock down the entire foundation system and the entire building, that's a very aggressive language that we don't want to get from applicants. I hope I made it clear this time.
Okay, thank you.
Thank you.
All right. Commissioner Shibata.
Thank you, Vice Chair. So I have some of the same comments. If their statement is true that the foundation was completed and there was work being done on the first floor by December of 2020, and that they spent 1.2 million on the development at that time, I would be satisfied. Although, like has been said by by my colleagues, we do need more evidence of this, photographs. We also need, as Commissioner Otley-Brown stated, separation between the expenditures that happened prior to December 2020 and thereafter. I agree with what Ms. Mattia said about the acquisition cost, although I would suggest perhaps snow removal may be permitted to stay if that snow removal was in the purposes of prepping the lot for work to be done. The issue that we've all been talking about is a serious economic loss. They do need to show that they need to show us how the work can be has been completed, can conform to any other use without sustaining a substantial loss, and they need to delineate that. I believe that practically speaking, I believe that they will have vested under this, although they need to prove that for the record.
Thank you. Commissioner Yoon.
I don't have any comments yet at this time.
Move on, Vice Chair.
Yes, yes.
Item number 22, 2021 81 BZY, 3860 11th Street, Queens. This is the statutory vesting application.
Okay, so we have received proof of service for initial filing and public hearing. The community board has waived. This is for statutory vesting pursuant to zoning resolution section 11-332 to extend the time to complete construction and obtain a certificate of occupancy for a 2-year term and to renew the building permit lawfully issued before December 20, 2018 for the development of a 9-story transient hotel in an M1 district post December 2018. So pursuant to zoning resolution 42111, the existing construction is vested since the building permit was lawfully issued prior to April 23, 2018. Though we have a confirmation from DOB. However, no TCO was issued by December 2021. So with that, section zoning resolution section 42-111 directs the board to zoning resolution section 11-332A and the findings related to the findings there are related to substantial completion and expenditure. Those need to be made. So the applicant has submitted the permit history, and we do see from that permit was issued in June. Foundation, according to the TR1, which was stated earlier, foundation was completed. But again, as Commissioner Otley-Brown stated, the affidavit doesn't seem to state that was done. It seems to have been done by the time of the sign, so it's not very clear. However, I think for the case of statutory, we don't need that exact cutoff that we need for the common law. For substantial construction to complete, Based on the case laws regarding vesting, there is a wide range of work completion. There's no established substantial construction test. The applicant in its document states that 100% of the site preparation, excavation, piling, shoring, and foundation was completed, has been completed, and the 2 floors of steels has been erected. Concrete slab has been installed to date, as I had mentioned earlier. With regards to the substantial expenditure, again, I think the comments what we have stated earlier carries here, which is the applicant has included costs that really should be not included. I'm going to add now acquisition costs to it, in addition to real estate costs, and those should be deducted from the total cost and indicate how much has been expended to date. And in this case, even though the applicant did not refer to the tolling, since the tolling period would apply in this case, it would toll till October 18, 2021. And so the applicant showed what is the cost that has been expended till October 18, 2021. The applicant did not provide any information with regards to time spent to construct, and that should be provided. So with regards to the serious loss, our prior comments from the prior case holds in this case, and those are my initial comments. So I think the applicant probably has a better chance of dealing with statutory from what I see, but the information is not complete. They need to clarify a lot of the information with regards to the expenditure made and the loss and the time factor. Commissioner Otley-Brown?
So here's where I get a little bit unsure and would like clarification. For the statutory vesting for the hotels, once you have proven that you're issued your DOB permitting and construction commenced by the 2 threshold dates, the prior to April 2018, don't you have until December 20th, 2021 as your new threshold of having to either have gotten a C of O, or then if not, then coming to the BSA within 30 days of that date?
So you are right. And this is where the applicant was not very informative, as we will hear it in the next case. But the applicant for the statutory vesting went through the detail of the tolling and how the tolling would apply. And in this case also, the tolling, the same tolling as the next case applies. So as I understand it, the effective date of the resolution is December 2020, and so the TCO had to be received within 2 years, so which means by December 2021, and within 30 days the application had to be filed, which would have been January 19, 2020. Now, because the tolling was put into effect as of August 31st, 2020, and was extended all the way to October 18, 2021. So once you extend it to October 18, 2021, so it was extended to, June 29, 2021. Now, that gets extended for completion to October 18, because you're separating out the difference between the June and the August to December period. You add that, you're adding the difference between the August and the December 19, 2021 to the June 29, 2021. That takes you to October 18, 2021. And then that gets, that means the tolling got extended to October 18, 2021, and the applicant has till November 17, 2021 to file. Am I wrong in saying anything?
I really don't know the exact dates. I thought it might be till December 20th, 2021, giving them 30 days, which means they would have had to file by January 19th, I believe, 2022 or thereabouts, which they did, but it just, if 12/20/21 is the threshold date and they filed by the beginning of January, and they're, in that case, I would accept the Ganesh affidavit is what I'm saying, because the threshold is no longer 12/20/2018. And so for the Ganesh affidavit to say 15% of total construction up to today, and today being their date of filing in January 2022, then I would find that acceptable because it's close enough to 12/20/21.
Okay, got it.
So that's why I asked the question.
Okay, I
No,
think they
and
are.
I do know that as for statutory, you have to show 100% excavation and 100% foundations. And as long as they can prove that, then I would be fine with them proceeding further. Then substantial expenditures, I have a similar question as you about taking out the expenditures that are not considered for statutory vesting, different from an appeals case vesting, and separate it out to pre and post threshold date. But I don't believe you need a serious loss determination for statutory vesting. So
Okay,
that I wouldn't have added that in as my comments other than
Okay.
that. And I'm okay with the rest.
okay, thank you. I think in the past, I've always reviewed the common law and statutory together. So I've looked at serious loss as part of both of them, but you're right. And our general counsel has his hands up. Please clarify.
Hi, I just wanted to mention with respect to the dates of the vesting of 42-111, please refer to 42-111E, which offers two different alternatives. And to the extent that the applicant's papers don't clarify, do clarify which path under 42-111E that the applicant is seeking their vesting under, which has a time bar for when a permit was obtained with respect to April 2018.
Right, actually, thank you for clarifying it. The subsequent application for statutory vesting, in that the applicant had clearly stated 42-11E. And I kind of assume that's what this case is also applying, but it has not been stated clearly in the statement of facts. So the applicant should clarify that. Thank you.
And Commissioner Otley Brown is correct. Serious loss is an element for common law vesting.
Okay, my mistake. Please take that off the record. Thank you. Is there anything else, Commissioner Otley Brown? Okay.
No, I have
Commissioner
no other questions. Sorry.
Okay, thank you. Commissioner Shetta.
Oops, I was muted. I apologize. Thank you, Vice Chair. You hear me?
Yes.
Yeah, I have nothing further to add. The only thing is that I noticed in the affidavit from Mr. Anish Gandhi that it's referring to block 2382 and lot number 27. And when I looked at the statement of facts, it's referencing block 474, 474, and lot 56. My understanding is that we're talking about same block and lot. So I would like them to clarify that. Other than that, I have no further comments to add. Thank you.
Okay. Thank you. Commissioner Shabbat.
Thank you, Chair. So I asked that the applicant clarify whether he's seeking relief under 4211E, whether the comments I've made with regard to substantial construction and expenditures remain the same from the last, from the sister case, I'd call it. The only thing I would put on the record for this case is there are still outstanding fees to be paid, and I wouldn't be prepared to grant under either without those fees being paid.
I think on that one, based on our prior discussions, as I understand it, there were the ECB violations were heard, and the applicant has been responding to the ECB violation. And there are outstanding penalties, TOB penalties that are outstanding. So while they are open, it seems they have been heard, but the applicant should clarify that.
Oh, and if the applicant wants to also state whatever tolling he's seeking to take advantage of, if any, that'd be important.
Yes, thank you. And I have to say, because I was reviewing all the other cases, I just assumed that, but you're right. We cannot assume this. The applicant should clarify that. And because it then works in its favor in presenting its argument. So the applicant should clarify whether the tolling has been applied in this case or not, which I think it is. Sorry, Commissioner Shabeta. Were you saying something?
Oh, no, I was just,
Oh, okay.
I was typing out loud.
Okay, Commissioner Yoon.
I have no comments to add at this time.
Okay, thank you.
Item number 23, 2022, 1BZY, 1227 Manhattan. This is
Okay.
also a statutory vesting.
Right, thank you. So we have received proof of service for initial filing and public hearing. Committee board voted to approve with condition. The condition is that the applicant and the board discuss and evaluate the merits of the applicant meeting the findings of zoning resolution section 11-332B3. I will discuss it towards the end of my statement, what that is. The applicant is seeking a statutory vesting pursuant to zoning resolution section 11-332 to extend the time to complete construction and to renew the building permit that was lawfully issued before December 2018. This building is very much under construction. It's almost nearing completion. Applicant, as it states, is awaiting a TCO, it's inspection almost. So this is a 38-story transient hotel the applicant is proposing, but we have to go through all the findings. And this was a very thorough submission and I felt the applicant walked us through the statutory vesting step by step and the tolling, how it applies. So in this case, pursuant to 42-111E, which is the vesting provision, the existing construction is vested since the building permit was lawfully issued prior to April 2018, and we have a confirmation from GOB regarding that. And section 2-111 directs the board to section zoning resolution 7-332. And based on zoning resolution section 11-332, if CO and TCO is not issued within 2 years, effective date of the amendment, in this case, which would be December 2020, the permit shall lapse and that the board may renew the permit for 2 terms, 2 years each, provided that the board finds that the substantial construction has been completed and substantial expenditure has been made subsequent to the granting of the permit. Because of the pandemic and to prevent the spread of it, on August 31, 2020, an emergency executive order was issued that told the 2-year deadline of ZR 11-332. And it was extended to June 29, 2021, which is 302 days from August 31, 2020. The deadline to complete the construction and obtain CO pursuant to ZR 11-332A was held until October 18, 2021, which is the difference between the starting of the toll period of August 31, 2020 to the effective date of December 20, 2020, added to June 29, 2021, and with a deadline to file by November 17, 2021, which is within 30 days after the lapse of the building permit. The emergency executive order did not toll zoning resolution section 42-111 and the vesting date of December 2021 with filing date by January 19, 2022. So the applicant is seeking extension pursuant to 42-111 with which directs to, as I said, to 11-332A. So the applicant needs to find that substantial construction has been completed. Applicant has submitted permit histories. We have a very thorough documentation of that. With regards to substantial completion, as I stated earlier, and the architect's affidavit states so that the superstructure and the floors were completed and 100% enclosed by December 20, 2021. And the time spent to construct, according to the documents provided, about 97% of the work has been completed, and 1,657 days of total 1,703 work days has been done, which is basically 97%. And substantial expenditure for application for payment as of 10/31/2021, 183 million was paid or incurred of the total 195 million. So which is more than 90% of the total construction cost has been paid and incurred. So I think this is very clear that the development is substantially complete, and the applicant has demonstrated that the development is substantially complete and the expenditure has been made. The only minor work that remains is closing, is to basically do some interior work and to secure a TCO pending a completion required by DOB inspection. Now, with regards to the community board's conditional grant, the community board wants board to discuss the application. Sorry. So wants the applicant to discuss section ZR 11-332B3. Now, it states extension of period to complete construction. B is, however, in the event that construction has not been completed at the expiration of the extended term specified in A of this section, such building permit may be renewed by the board for a term of 1 year, each upon the following finding. And the finding number 3, which the applicant with the community board stated, is that there are no considerations of public safety, health, and welfare that has become apparent since the issuance of the permit that indicate an overriding benefit to the public in enforcement of the applicable amendment to this resolution. The community board is stating this because there was fatality that had occurred during construction. So I want the applicant to provide a response to the community board conditions on this. I see. Okay, Madam Tony.
In my notes to you, I had raised a concern about that because there was some comment that there was litigation. So I don't know if council thinks that's appropriate, or general counsel thinks that's appropriate, or whatever you want to ask me, Madam Chair. I don't know.
Thank you I'm sorry, I did not see your notes. But if it is under litigation, then I understand that the applicant will not be able to discuss it.
Yeah, I don't know if it'll be appropriate, general counsel, if it's in litigation, would it be appropriate to discuss that?
No, it's also construction safety is DOB's jurisdiction.
Okay. Okay. All right, Commissioner Brown.
I also feel that they have proven that they have vested under 42-111E. I found this application to be very thorough. They showed us that substantial work was completed in a number of ways, in that they gave us photos that validated everything they stated. They stated what was actually completed in the statement in terms of listing what was done and what needed to be done, as well as giving us a ratio of days of work completed versus total days. So I found that very clear. They have met that finding. And as for substantial expenditures or paid or incurred, I felt that they were thorough as well with that. And so I have no questions.
Great. Thank you. Commissioner Shetta.
Thank you, Vice Chair. I'm not going to repeat what's said, but I do believe that they already vested on the point that the community board requested the board to discuss the incident that happened during construction. I don't believe this is the case. I did read the entire report from the community board, and what I believe is they indicating that they asked the applicant to provide some clarifications, and the applicant responded back to them saying that the matter is under litigation and he cannot do so. What I did understand, however, from the community board report, that they are asking the board to just look at the case based on the whatever rules in the zoning resolution, and if the board finds that the applicant has vested, then there is no issue. I do believe that they have vested. I did look at aerial images. I did look at photos submitted by the applicants indicating that the structure was like substantially complete on or before the vesting, the effective date. One more thing I want to say, that the applicant has submitted to us a set of structural as well as excavation support drawings, including foundation drawings. I just want to put it in the record that we have not looked at these drawings from the perspective of reviewing these drawings. We take them for records only, and we don't want to like be responsible for these drawings from structural perspective. Thank you.
I'm sorry, Madam Vice Chair, you're muted.
Vice Chair, you're muted. I was muted also.
Oh, I never muted myself, but thank you. Commissioner Shiveta.
Thank you, Vice Chair. I found this application to be very responsive. I found that they both had made substantial construction and substantial expenditures. I appreciated the way that they even used December 2020 date just to provide us with the information that was requested, even though they are going under 4211-111E. I'm satisfied with this application.
Commissioner Yoon.
I have no further comments.
Thank you. Should we go on?
Okay. The next case, I'm sorry. BZY calendar, continued hearing items. Item number 24, 2018-173 BZ, 128 Beach, 9th Street, Queens.
Okay. So bear with me. This application was last heard in February of 2021. So just to refresh, and for those listening in, the application is for a variance pursuant to zoning resolution section 72-21 to waive the bulk and parking regulations to develop an apartment building on a waterfront lot located in an R6 district in the Far Rockaway area. At the initial hearing, the applicant had proposed a 17-story mixed-use residential building with a community facility use, 60 dwelling unit, 14 parking spaces, and was seeking a waiver of floor area ratio, lot coverage, height and setback, and parking. The applicant had initially identified the subsurface condition and the waterfront proximity as hardship. The board questioned the subsurface condition as a hardship factor. And since the wetland regulations limits the lot area to 20%, which is more stringent than the underlying zoning resolution, this is the DEC wetland regulation, and that is, the board had questioned the waiver for FAR. The board also questioned the as-of-right development
You're frozen, Vice Chair.
In waiver of the base height and setback above the base height.
Sorry, excuse me.
Vice Chair,
Madam
Vice Chair, I have
Hold
to
on,
stop
Tony.
you. Oh, sorry,
Um,
Carlo.
I'm sorry. Can you just restart your statement again? You were
I'm
frozen.
sorry, I crashed. I'm
Yeah,
crashed.
No, you're okay now, but you were completely frozen, so we did not hear a portion of what
Anything. Oh my
No.
God. Which part did you not hear? Up to what part did you hear?
I think you should restate, just to be
Again?
clear. I'm
Yeah.
sorry, I know it's sort of redundant, but
Okay,
I think you should make it clear.
I apologize. I think generally I don't have this network issue. I really apologize. I can see my network is kind of going up and down, so I think we are probably having some issues here.
I think during a break, we should, we could try to work on something.
Okay, yeah. So very quickly, the application was last heard in February 2021. Just to refresh for those listening in, the application is for a variance pursuant to zoning resolution section 72-21 to waive bulk and parking regulations to develop an apartment building on a waterfront lot located in an R6 district in the Far Rockaway area. At the initial hearing, the applicant had proposed a 7-story mixed-use residential building with a community facility use, 60 dwelling unit, 14 parking spaces, and was seeking a waiver of floor area ratio, lot coverage, height and setback, and parking. The applicant had initially identified the subsurface condition and the waterfront proximity as hardship. The board questioned the subsurface condition as hardship factor. And since the wetland regulations limits the lot area, and the DEC regulation is more stringent than the underlying zoning resolution, the board had questioned why a waiver of FAR was needed. The board also questioned the as-of-right development initially proposed and the financial assumptions. So the recent submission from the applicant has responded to the comments that were last raised back in 2021. It is a very thorough submission and response to all the comments that were raised. The applicant has modified the scope of the project, that is reduced the ask, and is seeking the waiver of the base height and setback above the base height. That is, you're required to set back 15 feet above the base height and a 10-foot on a wide avenue, on a wide street, and a 15 on a narrow. The applicant is seeking a waiver of that and the floor area distribution and parking. So what is proposed now, the modified proposal, is a development of a 12-story residential building only, no community facility. And this reduces the floor area to 46,531, which is and it is well within the permitted FAR in the zoning district. It is therefore reducing the building heights to 118 feet, and the number of dwelling unit has been reduced to 55, which therefore reduces the number of on-site parking spaces, but still is seeking a waiver for 13 parking spaces. The previous ask was a 28. The requirement is actually 28 for a 55 dwelling unit. The applicant is proposing a waiver of 13 spaces on site. Due to the narrow footprint of the building.
Could I just break in? Excuse me, aren't they providing 13 and seeking a waiver of 15 spaces?
Oops, you're right. I misread it. I superimposed. Yes, thank you. App is proposing 30 spaces and is requesting a waiver of 15. Thank you. I misread my own comments. So due to the narrow footprint of the building setback, the floor area, the applicant is stating that first of all, DCA has a very stringent lot coverage requirement, which is maximum of 20% since it's a waterfront lot. The applicant is also stating that maybe they can seek a variance at DEC and may be able to increase it to 25%, but that application has just been submitted. There is no sign off on it. So the applicant is posing that the DEC lot coverage restriction supersedes the underlying zoning regulation. So therefore that is causing a hardship. And because of that, because the lot coverage is so less compared to what the zoning would allow, it is resulting in a narrower building footprint. And if the building had to set back within that, it would result in construction difficulty and also floor plates and room units that would be unnecessarily large. So the applicant is seeking a straight up building without any setback above the street wall height. The applicant provided a waterfront site study, and in that study, there are 21 sites that has been identified along the waterfront, and only other site that is similarly burdened to the subject site is site number 5. The applicant has identified that all the other sites have either more than 20% of lot coverage because they were constructed prior to the enactment of the DEC regulations, or many of them are cities, parkland or boardwalk, and some of the properties are separated from the beachfront by boardwalk or other properties. So I was satisfied with the uniqueness study, and I do believe the applicant has made the uniqueness based on the study that has been provided. With regards to the financials, I will look towards what Commissioner Otley-Brown has to state. But what I noticed was the applicant was asked to do the cost estimate based on Marshall and Swift, and the applicant has done that. And I just want to make sure the applicant has responded to Commissioner Otley-Brown's questions. In terms of the neighborhood context, the revised proposal is very much more within the context of the surrounding. We have super tall tower in the park kind of buildings around the site, and there are similar height buildings to the south, to the east of the site. So I think the proposed project is very much in keeping with the built context along the waterfront. Now, barring the financial hardship, I think the waiver that the applicant is requesting is reasonable and is minimal. So I'm satisfied with it so far. So with that, I ask Commissioner Otley-Brown.
So I am pleased to see that the applicant had listened to us both in reconstructing their as of right to give us what they could possibly build on the site if they were required to provide the amount of parking that they're supposed to provide. And in this case, they could only provide 13 parking spaces. And so therefore they were limited to 26 units, because you have to provide parking for 50%. And that actually provided the core of their argument financially, because their statement was basically, if we have to provide 26 units maximum within the floor plate that we could get, we would be forced to have unusually large units that are larger than what's actually found in this area, and also constrained floor plates for those larger units. And so all of that would make this project infeasible or contribute to it being infeasible. And so they used that as their an 11-story fully residential building with an FAR of 1.95, which is the maximum amount of floor area that they could fit on the site. And then from there, went to their reduced proposed project. And I have to say, I've looked at the financials and I have no questions, except for one which they can actually answer in the hearing. So I'll just go through it. For their site value, they actually provided 2 sites that sold in 2021 that are larger than the subject site and provide similar development abilities, and their sales price per available square footage came out to between $32.71 and ABASF. And that basically justified their usage of $66 per developable square foot in originally calculating their site values. So that stayed the same.
Okay, am I frozen?
No, you're not, am I?
Yes, you are.
Now you
Vice
are.
Chair is frozen.
So should I stop
You're good,
talking?
you're good. You're back. You're back.
Okay, so I was fine with the site value since I saw the additional
Commissioner,
sales.
please, Commissioner, I'm sorry to interrupt you. She's frozen again.
Oh, okay. Tell me
I'm
when to
sorry,
proceed.
Commissioner.
That's okay.
Okay,
All right, you good?
yeah, please proceed.
Okay, please proceed then, Commissioner.
Okay, so as I was saying, the addition of the two more recent sales actually justified their usage of a $66.04 for available building area land factor. And so the site value remains the same, and I'm fine with that. For their residential rents, their 1 and 2 bedroom apartments were the same as the previous report, but the 3 bedroom apartments that are in the as of right were actually higher than the previous report. And that makes sense because those are much larger units. So I have no questions there. I have no questions for the parking rent monthly, which is the same as before. And I had asked them to revalue the building in terms of construction costs using Marshall and Swift, and they used residential Class B could condition, and I'm fine with that. And their overall construction costs are now $390.52 for the as of right, and $389 a square foot for the proposed, and I'm fine with that as well. And now, so this leaves my only question. Their cap rates for all residential projects are 5.3%. And for all residential projects in New York City, developers are accepting lower cap rates. So could they just provide for me a justification for 5.3%? I do know that the delta for the as of right is very, very large between cost and value. So adjusting the cap rate downward would not really resolve that issue unless they adjusted it all the way down to like 2%. And I think that that's a little extreme, but because the 5.3 results in a project that just exceeds the development cost, I would like them to just justify 5.3. That's all. They could do that in the hearing. Other than that, I'm fine with the project as stands and very pleased with their change.
Thank you for that very thorough clarification on the financial. Commissioner Shetty.
Thank you, Vice Chair. Yep, this is second hearing effectively on this application, and we're almost there. Thank you to the applicant. They started with 2 components of the uniqueness. One is related to subsurface. We challenged that, and now they took it away. Thank you. They also reduced the size of the building. The only uniqueness component that's remaining now is the adjacency to the waterfront and the DEC regulations and its applicability. I did look at the waterfront study, and I can see now that the site is unique. So A is there, finding A is there. I did look at like the application in general, and I'm satisfied with it. Just one comment, I do believe that it's important. The applicant in the submission at the very beginning indicated that they applied for a variance from DEC to get the lot coverage of 25% instead of 20, which DEC dictates. However, that variance application to DEC was never approved. I believe they said they want to they intend to take our grant and then proceed with the DEC variance. However, I would caution the board that the plans presented to us indicate 24, almost 25% of lot coverage. So I would recommend that we add a note to the plans indicating that this board is not waiving any DEC regulations, nor any flood regulations because that site is totally within a flood zone. Other than that, I'm satisfied with the application. I thank the applicant for being very responsive and ready to move forward with it. Thank you.
Okay, thank you. Commissioner Shabbat.
Thank you. I do not want to be repetitive, but I am happy with this application. I found it to be very responsive. He answered all of our questions and scaled down the project quite a great deal. The only thing I didn't see was, is seeker still, has anyone received seeker? Is that still out?
I think that is still out. Tracy?
Sure. Can you hear me?
Yes.
Yep.
Yes, we received the revised EAS on July 21st. So we sent that to the agencies. So we still have open reviews for WRP, shadows, and noise, as well as the revised EAS stated that further analysis will be undertaken regarding natural resources. So yes, there are some open issues.
Okay. So that's all I'm waiting on.
Thank you. Commissioner Yoon.
Thank you. I don't have any comments at this time.
Going back to the DEC, so the applicant, I believe, in the past had applied for a DEC variance and was granted close to 25%. But anyway, that expired. So the applicant has again submitted an application, I think, unless I misunderstood. The bottom line is, you're right, Commissioner Sheta, is that if DEC does not grant the 24.5, whatever lot coverage the applicant is proposing here is not granted, then the applicant would have to come back for an amendment. I would think so, but that's for the applicant and its team to determine. Yes, Mr. Costanza.
Yeah, no, Madam Vice Chair, that is correct. Unless any changes are suggested by DEC that don't implicate any of the waiver areas, then perhaps administratively we could look at this, but we don't know at this time. So it's really contingent on the outcome of the DEC review.
I just want to note, I don't know if it was mentioned, but there's still, I'm not sure if they filed, obtained the waterfront chair certification from DCP yet.
I don't think so.
I don't think they've received
No, they
it.
did not.
Okay.
We're waiting for that.
So I guess it's those three things then.
Mhm.
Yeah,
Oh,
we
I'm
should-
sorry. I apologize. I was talking about seeker. Are you discussing a different waiver from DCP?
Yeah, so there's the water revitalization certification, but this is also, I believe, subject to Article 6
I see.
for the waterfront, which requires a certification from Department of City Planning. So perhaps the applicant can just brief the board on statuses and timelines.
Yeah, I think the applicant said that would happen after the BSA approval. So I don't know if that is something we would accept. It's not quite clear to me. So yes, the applicant should clarify that during the hearing. Okay.
Vice Chair?
Yep.
Yeah, regarding the DEC variance, I usually copy and paste from the applicant submission, and the initial submission did clearly indicate that they haven't received a variance from the DEC regarding the raise of the lot coverage from 20% to 25%. So I'm not sure if they received the variance and it was lapsed, or they haven't received it at all. So they might need to clarify that.
Okay, yeah. So the applicant can clarify that during the hearing.
Okay.
Thank you. Okay, move on to the last case of the day.
Okay, item number 20, did we go through everyone?
Yes,
Yes, we did. Sorry, yes, we did. Item number 25, 2019-277 BZ, 8104 166th Street, Queens.
So this application was last heard on May 10th. The board had directed the applicant to revise the plans, eliminate the moat and reduce the building height. Also, the board had asked for a future clarification on the number of congregation and room utilization. This is an application for a house of worship. The applicant has responded to the board's comment. The proposed building has been modified. Third floor of the building has been eliminated. Now it's a two-story building with a cellar, full lot cellar. The entrance to the building is from grade. In addition, the facade design has been revised significantly, and that is much more representative of the residential built character. So the proposed floor area is reduced thereby, and the building height is reduced to 30 feet. And the elimination of the third floor also reduces the scope of the waiver with regards to FAR and the front wall height waiver. The applicant will still require a waiver for the front yard depth and the side yard width. The applicant was also asked to provide the number of congregation and room utilization analysis, which has been provided. And with that, the yearly growth projection. The statement estimates that by 4 years, the facility will be fully operational to its maximum capacity. We did receive a letter of opposition from the neighbor, and the neighbor is concerned about construction safety. I think any development on the site will have to comply with the New York City DOB regulations, and DOB will be responsible for reviewing and approving the construction plan and will be responsible for compliance with regards to construction safety. So with that said, I'm very satisfied with the revision made, and the proposed project is now more in keeping with the residential build context. Commissioner Otley-Brown.
I am also satisfied with the project as it is now. I found them to be very responsive in terms of detailing the current congregation and showing the growth through the fourth year, and also showing that the rooms, while they may seem large, hello, am I frozen?
No, we can hear you.
No, it's Madam Vice Chair. It's froze for a second.
Oh,
boy.
okay. Tell me when I can go.
Please, please continue. Oh, again, frozen. Okay.
Okay, so I found the submission to be very responsive, and they fleshed out what their current congregation is and showed the growth through the fourth year. And while the rooms seem a little large for the current year, you can see that by the fourth year, they will be filled 100%. I found the room utilization chart also to be very responsive because it showed simultaneous use between the synagogue and the multi-purpose room, because the multi-purpose room would have the youth groups during the Sabbath morning prayer. I feel that this is a far more modest project at 2 stories and cellar. And the fact that where there are windows, they're going to be opaque and inoperable alongside their residential neighbors, I find to be respectful, and I'm okay with the project.
Okay. Yes. Thank you for bringing that to my attention. Yes, I had it in my notes regarding the opaque window and maintaining a noise attenuation level of operable windows to STC level. Yes, those notes, I believe, have been added to the plans also. So Commissioner Sheta.
Thank you, Vice Chair. I'm not going to repeat the comments from my colleagues. I want to thank the applicant. The application was very decent. Now the building is much more residential and neighborhood friendly. I would urge the applicant, however, to address the concerns from the neighbors. In other words, I want to hear the applicant explain and send messages on that hearing to the neighbors that there are several means to ensure that the neighbors will be safe during construction. One of these things is that the applicant would need to build an excavation support to make sure that the neighbors are not impacted. It's going to be a monitoring during the construction process. There are lots of requirements by the government and specifically the DOB to make sure that adjacent neighbors are not impacted negatively by a construction process in general. So I would urge the applicant to like explain to us and to the neighbors how they will like take care of ensuring that. And this is, again, this is not a requirement from the board. It's a suggestion or recommendation from us. So we keep a good relation between two prospective neighbors. Thank you.
Thank you.
Thank you, Vice Chair. Again, from this applicant, another very responsive submission. I appreciate the way he's addressed each of our concerns, and the FAR that he went from to 2.2 or 2.4 to 0.79 FAR. I just think it's really in line with both the neighborhood and our request and the neighbors. So I'm satisfied with this application.
Commissioner Yoon?
Thank you. I have no comments.
I think I froze again. Okay. So I just heard the tail end, Commissioner Yoon. Commissioner Yoon, sorry, I think I froze again.
You're frozen again, Vice Chair. Vice Chair?
Maybe we should go to break, and because that's
I
the
just had a
best case.
question. Yeah, I just had a question now. Vice Chair, you good? You're
She's
back.
I'm back. I'm sorry. Commissioner Yoon?
I'll repeat. Thank you. I don't have any comments at this time.
Vice
Okay.
Chair, I have a note in my note. Anyone have an issue about the mikvah? The mikvah is still there. Am I wrong?
The mikvah is still there, and the applicant has provided a reasoning. And I
Everybody
think
was fine.
I was satisfied with the reason that was cited.
Okay.
And I think our primary concern was with the third floor and the use proposed and how that lines up with the congregation, number of congregants, their program. And I think as we have all stated, the utilization, the number of congregation and the growth factor line up with the two-story building, and the need for additional office space and classrooms or whatever that was being done on the third floor is not justified. And I don't, so that was really our primary concern.
Okay, great. So this concludes, no more questions? So this concludes the public review session. Do you want to take a break or? move
So
on?
it's,
If I can
yes.
if I can make a suggestion, I don't know if everyone's amenable, but perhaps breaking for lunch now so we can try to work on the vice chair's computer, because it's gonna, it's quite a few cases that we don't
Yeah.
want to keep hiccuping.
Going, right. So it's 12:23. So should we meet at 1 p.m.?
Yes.
Okay, cool.
Thank
That's a
you.
resounding
Yes, it is. Then.
A resounding yes. Thank you very much. Okay.
Thank you,
Um,
everyone.
Okay.
Thank you.
Thanks.
Vice Chair, you wanna disconnect your video?
So, yeah, I think everything is okay. As I was repeating I'll repeat myself since I was muted when I was talking to you. I was previously, all my hearings, I used the iPad for Zoom, and I was using the laptop for all the note taking. And now, today I was doing everything off the laptop. So I think that slowed down the laptop because the network here is very strong. Can you hear me, sir? Yeah.
It's good news. We're up and coming.
So I-
Sounds muted. Vice Chair, though, the computer is blocking you. Your laptop is blocking your visual.
Oh, I see. Well, in that case, I have to bring it back to the old look. You get to see my beautiful side profile.
Much better.
How about that?
That's
Wow.
much better.
Yeah, the side profile looks better.
No close-ups, Mr. DeMille, right?
Yeah. I apologize. What happened was I was running everything from the laptop, and I think the laptop was not able to take the bandwidth.
Yeah, considering a decast outage today and everything else.
Yeah. Let me increase the height of the thing. Or maybe I should reduce or should I increase the height or reduce the height? Which one is it?
Like John Lennon said, there's no problems, only solutions.
Yep, I hear you.
Whoa, somebody's
Yeah.
screen sharing?
Okay, I think
We're good to go?
so.
Shall we start?
Is everybody here?
We have a quorum.
We do? Okay, good. I can't
Everybody's
see.
here, yes.
Yeah, okay, I see everybody. Okay, all right, let's start.
We're live, right? Yeah. Okay, thank you, Steve. Good afternoon. This is the Board of Standards and Appeals public hearing for August 8th, 2022. The first item up is item number 14 on the SOC calendar, compliance hearing 2019-27BZ, 4533 18th Avenue, Brooklyn.
Okay.
The applicant's representative won't be making an appearance for this. I just ask, as I stated in the review session, that the board make a motion to close, but hold this on the calendar until the letter of substantial compliance application is filed and fully prosecuted.
Okay, all right.
Chase, do we not go to the public or anything like that?
No, this is just a compliance hearing.
Okay, fine. Just double checking. Okay, so Vice Chair, do you want to?
Okay, motion to close.
Chair, Vice Chair Chanda,
Aye.
Commissioner Otley Brown,
Aye.
Commissioner Sheta,
Aye.
Commissioner Shabeta.
Aye.
Thank you. Commissioner Yoon,
Abstain.
okay. Continued hearing items on the SOC calendar, item number 15, 6690BZ, 4303 Astoria Boulevard, Queens.
Okay, so who do we have? Are we expecting Miss?
Would be Ms. Folder and Mr. Stewart.
Okay.
I'm here. I don't have video. This is Andy Stewart.
You have no video? You can't join as a panelist? Okay. Ms. Folder, please unmute.
Yeah, there we go. Thank you.
Okay, raise your right hand. Do you affirm to tell the truth, the whole truth, and nothing but the truth in your testimony before this board? And to respond honestly to board member questions?
I do.
I do.
Please
Elise
take your name and seat.
Elise Fullader from Eric Palatnik PC. I just want to say thank you so much for all of the thoughtful comments. And then I wanted to say welcome to Commissioner Yoon. We really look forward to working with you. So excited to work with you in the future. And now I'll get to the comments. So we listened to all of your comments and I'll just go through them one by one. And Andy's here if you need any clarifications. There were additional shields that were being added. Thank you for noticing. And we'll add a note to the plans that clarifies that. In photo number 12, we will remind the operator to remove the excess banners on the lighting poles, and they will be removed, and we will take photographs. We will add the note that says that the sign will comply with C1 signage regulations and DOB shall approve. And you are correct about the landscaping. It has not been put in yet because we need to have the trash enclosure built, and then we will have the landscaping updated. And then lastly, we'll add a note to the plan that all lighting sources that are located adjacent residential uses shall be shielded from direct view and to minimize any adverse effect on surrounding residences. And I think those are all of your comments.
And on this one, the additional note just for file would be for resolution would be that should, and that will be part of the condition also, that should residential neighbors raise any complaints regarding excess lumen spread, that the applicant will work with its neighbors to address those concerns.
But is that just in the resolution or should we put that in something?
It would be in the condition.
Okay, no problem. Thank
you. Ms. Matias, do you have any?
Out of lights, my note, there was a note about revising the plans, or do you not want the plans revised?
The plans will be revised to add the notes regarding C1 signage, the lighting note, and the excess banners will be removed from the plans. So anyway, they were never counted, but the note will be added to that effect.
Okay.
Commissioner Otley Brown, do you have any comments?
No.
Any other comments from any of the commissioners? Commissioner Shetta, Commissioner Shibata? I'm seeing their heads going sideways and saying no. Commissioner Yoon?
No.
Okay, so I don't think any of the commissioners have any comments.
So, Madam Vice Chair, if it appears that the board might be in a position to consider closing the matter, we should just go to the public.
Yes, that's what I was going to suggest. Thank you.
Yes, I'm waiting.
Yes.
Okay. The matter we are discussing currently is 6690BZ 4303 Astoria Boulevard, Queens. This is an extension of term for a automotive service station. Should you wish to discuss, please dial in 646-558-8656. You will enter the webinar ID number 853-4000-0736 and press the pound sign. At the next prompt, you will only press the pound sign. Once you're in, you will press *9 to raise your hand, *6 to unmute to be able to speak. If you are already in the Zoom room, please raise your Zoom hand. And that's that little hand that's on the bottom of your screen.
Okay, so we'll wait for about a minute or two.
Understood.
And I think this would be a good time to find out how long will it take for you to make these corrections?
Since we're gonna need photos, I would say a week or two just to make sure we get the operator to take everything down and get good photos for you. Just want to ask you about the landscaping and the trash. That also depends what you want to do with that. So.
Okay, so I think if you can do it, because anyway, the next hearing is not, I don't know what the availability of our schedule is for September. It's kind of tight. Okay. But if you can do it, please do, and you can submit the photos about if we can get you in on September. I'm not promising anything. If we can, then do provide the photos before that. If not October, then you'll have plenty of time to close and do it. That would be my recommendation. and just provide the photos of the completed work. If you're not able to do it, then, I'll have to put in additional conditions.
Okay, understood.
Okay, so we will try for September, if not October, because our schedule is pretty packed for September. And I hope you understand.
Totally. There's a lot of holidays I know that come up, so a lot of people are put on the September calendar.
Yeah, so if you can get most of it done between, I would say aim for October. That is more realistic.
Mhm.
So we haven't heard anything back from anybody. So if you can get it done before the October hearing, then just provide photos of all the work that has been completed. And, it's great. Then we will just add just those two conditions, the condition of the working with the neighbors should any issues come up. And
Sounds
that
great.
will be done.
Thank you.
Okay.
Mhm.
Yeah, just FYI, the submissions for the October 3rd, 4th hearing would be the 14th of September, but I'm assuming that, Vice Chair, that if it's just photos, maybe you're fine
You
with
can
it
do
close
it like
enough to
a
the
week
hearing.
before.
If it's plans, the 14th of September.
Right,
That's
do
fine.
submit the plans beforehand. The photos you can submit 1 week before the hearing. We don't like to be inundated till at the last moment, because sometimes, so many emails are coming, we sometimes miss them. So it's better to do it 1 week before the submission. And since you have so much of time, I think you should be able to get it done.
Yeah, I think that sounds great.
I'm sorry, I missed, this is tentatively for like October 3rd?
Mhm.
Yes.
Okay. Okay, I'll make a note. And Ms. Falder, obviously the staff will be reaching out to you within a day or two. And then if there's any, hiccup or anything, just let us know and I could reschedule accordingly, okay?
Thank you so much.
So it's the trash enclosure and the landscaping and removing the banners.
Right. And the
Right.
C1 and the note on the plans that, about the signage.
Mhm.
All right. So should we then, I'll make a motion to close.
Yes.
Sure. Vice Chair Chanda,
Aye.
Commissioner Otley Brown,
Aye.
Commissioner Sheta,
Aye.
Commissioner Shabeta,
Aye.
Commissioner Yoon.
Abstain?
Okay. Item number 16, 12992BZ, 15055 Cross Island Parkway, Queens.
Just give me a second. I'm just finishing.
Notes.
Yeah. All right. So Cross Island Parkway, who do we have?
Lisa Arantia.
Okay. Anybody else? Do I
Could someone make
see?
me a host, please?
I don't see Miss Arantia.
She's in the room. There she is. Okay. Is anyone with you, Miss Arantia?
No, just me.
Okay. Vice Chair, may I proceed to?
Yes, yes.
Okay. Raise your right hand. Do you affirm to tell the truth, the whole truth, and nothing but the truth in your testimony before this board, to respond honestly to board member questions?
Yes.
Okay.
Okay.
Good afternoon, Lisa Orantia, representing the applicant in this application to extend a variance term. I heard the comments earlier today, and I just want to confirm regarding plan revisions. Is there a request to revise the drawings to note lighting directed downward and shielded from adjoining residences, or is that just going to be a condition of the resolution?
Okay.
My note said it to be added, but Vice Chair?
Yeah, I'm just looking through my notes. I think it meant to be added to the, note to the plan.
Okay, we'll do that. Second, potential revision was the comments about the key for the retaining wall. I believe it was the former chair that requested that we add the key. And the key was shown in the 1993 approved drawings. So those are now reflected in the current set. But we can revise if that's what the board is asking for.
Can you explain what is meant by the key? Because my understanding as an engineer to the key might be different from an architect.
Yeah, well, I relayed the comment to the architect, and what we understood is that it just makes a reference to section A-A. So the architect added an indication of the A-A where it's taken from the location, where the detail is taken. And that is exactly what's shown in the approved 1993 drawing set.
Okay, I see. So this has been built.
The retaining wall, yes, it's existing. We could note existing wall if that helps.
I think that would be helpful to indicate that this is an existing wall. But Commissioner Shetta?
Yeah, I did look at the previous submission, and it sounds like the section AA of the retaining wall didn't change. I do strongly believe that it was a confusion from whoever attended the last hearing from the applicant representative, and probably they misunderstood that the board is asking for a key to be shown. I did listen actually when I saw this yesterday, and I did look at the hearing, and I did listen to the entire testimony of myself under the impression that I was, if somebody's gonna ask for something like that, it should be me, because my understanding for the key is a structure. It's the shear key that connects the stem of the wall to the footing of the wall. If you want me share the screen and show it, I could do that. But I did look at the previous submission, and the shear key was there. So even during the past hearing, it wasn't making sense for me that I did ask for something like that. And I believe if somebody else on the board did ask for it, I would have said, hey, the key is there, don't ask for this. I believe it was a confusion. What I wanted to say is just this note is not raised by, this comment, I'm sorry, is not raised by us, and the response to it will be just ignored. There is no big deal about it. If you're okay with that, we can just like leave it there.
May I make a suggestion? Since it is already built, and the applicant state that it has been built pursuant to what the previous approved plan was indicated, let it just state as existing retention wall thing as a note. So this way, if the future board members want to know how the wall was constructed, should there be any failure in the thing, it was built pursuant to what was approved in 92, and it was existing at this time, at the time when we voted. So just for that, if you could add a note saying that this is an existing retaining wall, and this is a section of the existing retaining wall. That way, we are not opining on it. It's just there for the completeness of the record, indicating that this was built, this retaining wall was built pursuant to this diagram. Is that clear to everybody?
Yeah, understood. And then the last comment is regarding the zoning resolution determination, and that's regarding the applicant's request to legalize the canopy at the rear of the site. And the board raised the question as to whether the canopy created floor area. And the applicant's intent is to remove portions of the enclosure so that the canopy does not create floor area. And we are in the process of getting that determination from DOB. We believe that we've shown that the portion of the enclosure that is proposed to be removed will not allow the floor beneath the canopy to be counted as zoning floor area. The issue we're having with DOB is that DOB understands we're asking for this in connection with the current application. Now DOB wants to hear from BSA what it is the BSA wants to know. They don't want to hear it from the applicant. So we would appreciate having BSA staff, and I'm happy to attend the meeting with DOB, but in some way to communicate to DOB that the board is asking for clarification as to whether the canopy creates floor area.
So as I understand it, and you have revised the plan based on the ZRD1, where as the structure stands today, it would result in non-compliance with regards to floor area, as the structure stands today.
Yeah,
So
existing.
you are right, the existing structure that is built today. And in order for it to not increase the additional floor area, you are proposing to amend the canopy structure by not having the perimeter wall for a certain length of the area.
Right.
And that's what is there before ZRD. That is what's reflected in the ZRD1, and that is what is before BSA.
Yes.
I think the question that the board has asked is, now that that has been done, now that we have addressed the fact that the existing structure as built doesn't comply with the floor area and that an amendment is being made, what we want to further make sure is that what is being proposed will also comply and therefore not result in additional floor area.
Right.
Right? I think that's the only clarification we are seeking from, and correct me if I'm wrong, General Counsel and our Executive Director, at this point, what we would want the DOB to ensure and give us guidance that the proposed modification that is proposed, that you have, which is removing a portion of the perimeter wall that rises to the full height, with the elimination of that, I think it's 23-foot length or 28-foot linear length, the structure that would be in place would be in compliance and therefore would not add to the additional floor area. We want to make sure that DOB can sign off on that. And with that, then we can proceed with the application. Because we want, otherwise it would require an amendment.
That's correct.
Yeah,
Okay.
the problem is that DOB wants to hear directly from BSA. We've
Okay.
explained it to them, but they want to hear from BSA.
Ms.
Okay.
Sarabia, can I just ask, so the ZRD1's been filed already?
Yes.
Yes.
Yeah.
And it's been filed with this proposed iteration or the existing condition?
No,
Proposed.
it's proposing to remove portions of the enclosure.
Can, I'm sorry, and if it's in the file, I apologize, I just didn't look, but if it's not in the file, can you forward the General Counsel and myself whatever materials were sent to DOB?
Sure.
And then we could try to coordinate something to see if we can get a response expeditiously.
Yep.
Right. The ZRD1 is in the file, and so is the proposed plan that has been submitted. It's the same proposed plan that is included in the ZRD1. Am I correct, Ms. Arantia?
Yes.
Yes.
Yeah, thank you.
So,
Sorry, I wasn't in the file. That's why I asked. I just wanted to confirm that we have everything we need.
right. Okay.
All right,
So
so we'll reach out to Ms. Orantia after the hearing, maybe in a few days. And General Counsel and myself will reach out and try to schedule a discussion with DOB.
Great. Thank you.
Carlo?
Yes.
Yeah, Vice Chair, I'm suggesting that whoever is going to reach out to the DOB for the purpose of like shortening the span of these back and forth, my understanding is that every applicant is in a rush to get his case done. If the question could be an additional question, actually would be like sent to DOB. If the current proposal constitutes an increase in the floor area, what would be done to like?
Commissioner Shatas, so I think we need to be clear. The current plan, the existing plan, all the E drawings, right? That is showing the existing built condition. And in that, the applicant is, so we have that. The applicant then went through the entire analysis, the floor area analysis of the perimeter wall condition per 12 section definition of floor area, and determined that the existing structure as it stands with the full height enclosure of the corrugated metal fence on all sides, it will result in an additional floor area.
Yes.
And the applicant is basically correcting that
Yes.
and is proposing to modify that. So what is before DOB is not the existing plan. What is before DOB as part of the ZRD is the modified plan with the removal of the corrugated metal fence. Therefore, the corrugated metal fence that is removed would make it compliant. And what I'm basically saying that what we need to get a read from DOB is what has been proposed, but not built, what has been proposed is compliant.
Yes, that's exactly what I said.
Okay.
I said if the DOB says that the proposal currently before them in the ZRD, not the existing conditions.
Okay.
If they say they are not constituting an increase of floor area, pinky, done. But if they say, nope, still we have a problem, I would suggest, for the sake of like shortening the back and forth, for the benefit of the applicant and the owner, to add a new, like additional question, what do you think could be done to eliminate that kind of increase? And if they come back, we say do 1, 2, 3, if the applicant is willing to adapt this 1, 2, 3 procedure, again, we're done. So, but if the applicant is not willing to take what DOB is requesting, then they can pursue whatever they want. I wanted to like shorten the loop, and instead of 2 trials, just 1 trial.
Okay, we discussed.
Am I clear?
General Counsel?
Hi, I understand what the commissioner is stating, and we'll request any guidance that we can from DOB when we have the meeting.
Okay. Thank you.
Thank you, Counsel.
All right.
I believe that was all of the comments from this morning.
Yeah. So I think I'm, how long will it take? Let's go to the public. We can discuss this while we're waiting for public to call in.
The case we are currently discussing is 12992 BC 150-55 Cross Island Parkway, Queens. Should you wish to call and discuss, please dial 646-558-8656. Enter the webinar D number 853-4000-0736 and press the pound sign. At the next prompt, you will press only the pound sign. You press *9 to raise your hand, *6 to unmute to be able to speak on the phone. If you are in the Zoom room already, please raise your Zoom hand, and that's the little hand that is at the bottom of your screen.
So, Ms. Arantia, how once we do reach out to DOB, once our general counsel and executive director reach out, how long do you think it will take for DOB to weigh in on the ZRD one?
It typically takes DOB at least 2 months, maybe 3. I mean, they might be willing to expedite given that this is a BSA case.
Okay. So we could do one of 2 things. And I look towards my board members. We could close it and wait for the ZRD1 determination. If it can result in 3 options. One is DOB says, what you're proposing is compliant, good to go. We just close and we just wrap it up. I mean, we just basically approve at that point because it's been closed. If DOB approves but puts in some caveat, then those become part of the conditions. And those need to be then reflected in the drawings and it would become part of the condition.
The third one is if DOB says, no, this results in additional floor area and you have to remove more panels to make it compliant, or you have to do more changes to the proposed plan, then we have to reopen it, you have to resubmit the drawings. Is that okay? And is there anything that I'm missing?
Isn't there an amendment? Then we'd have to file an amendment, correct, Carlo?
Well, I mean, if
Well,
they're
that's only if the, I mean, again, the
Right.
board would have to consider that legalizing whatever it is, rises to the
That is the
amendment,
form-
or the applicant removes, brings it into compliance.
right. If the applicant brings into compliance, there's no added amendment, but we will have to reopen to accept the revised plans and all of. But if the applicant is going to amend it by trying to legalize the existing structure, then we have to reopen it again. So is that reasonable? And I want to hear from our fellow board members. Are you okay with it if we were to close today? And then we have these 4 paths forward based on the DOB review.
I'm okay with that.
Yeah.
Yes, that's an excellent plan, I would say. Yes, I'm okay with it.
Okay.
And
All right.
Madam Vice Chair, I mean, if it's
Yes.
amenable to the applicant, we could close it and put it on for decision, giving a generous amount of time. I don't
Yes.
know if that would be
Yeah.
okay, but I mean, there's the end of October or November, something to that, and again, at that time, if for some reason the issue hasn't been reconciled, we could always give it a short adjournment.
Right. Yeah, I think I would say November, just to be on the safe side.
I'm sorry, is it possible if we get an answer sooner to get it back on the calendar sooner?
So September is not at all possible.
Oh, okay.
October is kind of iffy. Maybe the second part of the October. We have 2 hearing dates in October. Maybe the second hearing date of October is possible. And I haven't looked through the entire list, so I cannot tell you. But September is not possible.
Got it. Okay.
We can consider the second hearing in October, which is the middle.
Okay. Okay. All right. I think let's shoot for then second.
Which would be the 17th, 18th.
Okay, October 17th and 18th. And so, Mr. Rantia, you know the path forward. Of course, the best solution will be where DOB nods the head and says, yes, the proposed one is perfect. No issues. If there are any conditions, please make those revisions to the plans and submit it at least before the submission date for October 17th and 18th. I think it's 2 weeks before.
Right.
And if you need to amend the drawings based on DOB's determination that the proposed one still is not in compliance, you will have to do the same.
Right. Understood.
So if you were going on the October 17th, 18th, submissions would be due September 27th.
So,
27?
Yeah, I know there's observance days, so I don't know if that's an issue.
I think you
Are
can,
we
because
scheduling?
if it's okay with you, Mr. Rantia, because it's a DOB, and if you're not able to get your hearings by September, I would say make it the first week or the second week of October. I mean, at least a 2 week, we generally give a 1 week gap, right? Or a 2 week gap before a hearing.
Yeah.
So,
So you're
the
amenable to
staff-
that, Commissioner?
Yeah,
Okay.
yeah, staff will reach out to you and let you know when the submission date is.
Okay.
Okay, so do we want to take a vote? To
Yes.
close? Okay. Vice Chair? Motion to
Aye.
close?
Yes, motion to close, aye.
Commissioner Otley Brown?
Aye.
Commissioner Sheta?
Aye.
Commissioner Shabeta?
Aye.
Commissioner Yoon?
Abstain.
Okay.
Okay, thank you.
Thank you.
The next item is item number 17, 21406BZ, 19625 Hillside Avenue, Queens.
Okay, I think we have, I think this would be Ms. Fullader and Mr. Stewart.
Hi, how are you? Is Andy here as well?
Andy's still
I'm
there.
here.
Okay,
Yep.
great.
Okay, raise your right hand. Do you affirm to tell the truth, the whole truth, and nothing but the truth in your testimony before this board, and to respond honestly to board member questions?
I do.
I do.
Elise Fullader from Eric Palatnik PC. Thank you so much for your comments. I believe the only comment on this one was we will add a note to the plan that all lighting sources that are located adjacent residential uses shall be shielded from direct view and to minimize any adverse effect on surrounding residences. And then you spoke about if there's any complaints, we will address those from neighbors.
I actually, okay, fine.
Oh, sorry.
If you want to do that, I was going to make it easier for you by not make you add the notes to the plan, but we can make it part of the condition.
Whatever,
Since
we'll
this
take
case-
that, obviously, if that's easier for us.
And I'm really making this, sorry, go ahead, Ms. Matias.
I'm sorry, I
Ms.
didn't want you to go ahead. I'll wait till you're finished.
No, I think in this case, you have this is an exception I'm making because you have submitted the plans, everything based on what we had asked for.
Mhm.
And this is something new that we have added.
Okay, no
And
problem.
since you don't have any more changes to add to it, that's
Mhm.
why we can make this a condition. And the community board asked also. Yes, Ms. Matias.
I have a notation about no parking on the sidewalk.
Yes, that will be part of the condition also.
Okay.
Mhm.
That note doesn't need to be added to the plan. That can be part of a condition, the resolution. So
That sounds perfect for us, and we totally understand that, and we can add that note to other different cases.
going forward, please add that note to the plan.
Mhm.
Understood.
Okay, let's go to anyone else? Go to the public?
Yes, let's go to the public.
No, does anyone? Did you want to ask the commissioners?
Oh, sorry, I did not ask that. Did our commissioners have any comments? I'm seeing everybody shaking their head. No comments, right?
Okay.
All right, questions?
Maybe a timeline for the submission to be made?
Well-
If there's no submission?
No, there's no submission.
Okay, the case we are currently discussing is 21406 BZ 19625 Hillside Avenue, Queens. Should you wish to discuss, please dial in 646-558-8656. You will enter the webinar ID number as 853-4000-0736 and press the pound sign. At the next prompt, you will only press the pound sign. Please press *9 to raise your hand, *6 to unmute, and if you're in the Zoom room already, please raise your Zoom hand, which is the little raised hand signal on the bottom of your screen.
Okay, so maybe we can close the, I don't know if September we can put this. If not, definitely we can have this on for October.
No problem.
Okay. Let's wait to see if anybody wants to chime in. I think 1 minute is up, is it?
Mhm.
All right, so motion to close.
Chair, sorry about that. Vice Chair Chanda,
Aye.
Commissioner Otley Brown,
Aye.
Commissioner Sheta,
Aye.
Commissioner Shabeta.
Aye.
Commissioner Yoon.
Abstain.
Thank you. Okay, I'm sorry. Just let me get my papers. Next item, new cases, item number 1833790BZ, 1415-17 East 92nd Street, Brooklyn.
Okay, this is a Sheldon Lobel application.
This is Alexia Landsman.
Hello, can you hear me?
Yes. Is anyone with you, Alexia?
I believe Peter Mugavero, the architect, should be joining us, but I think he'll begin, and when he joins, he'll just be admitted.
I don't see him in the room.
He's being promoted to panel.
There he is.
Oh, okay, thank you. Oh,
Perfect.
thank you, Chase. Mr. Mugavera, could you unmute when you're able to and accept as panelist, please? Thank you. Please unmute. Thank you. Raise your right hands. Do you affirm to tell the truth, the whole truth, and nothing but the truth in your testimony before this board and to respond honestly to board member questions?
I do.
Please state your name for the record and proceed.
Peter Mugavero from PGM Architects.
And my name is Alexia Landisman on behalf of the applicant from Sheldon LaBelle PC. So good afternoon, commissioners. We have attended the executive session and we would just like to address your comments in the order that we've received them. The first question that we received was whether or not the adjacent residential property complained about the site. And we're here to say that there has been no complaints issued. And in fact, when we presented in front of the community board, we had provided notice specifically to the next door neighbor as an opportunity to have any comments and attend the meeting. There were no complaints from their end, and there was unanimous acceptance from the community board. The second question was whether or not the auto repair shop has had the same use and maintained the same, just the same plans, and that's accurate. The automotive repair establishment has remained exactly the same since its legalization in 1992 for that variance. The third comment was whether or not the calculations, the zoning calculations on plans needed to be corrected, and we can submit revised plans reflecting the R5D C13 zoning district on the plans. The board had requested operational plans to be submitted, and we are happy to submit that at a later date after we discuss it with the applicant and figure out what we can do for the site to make it operationally sound. The next comment that the board had requested was the signs and the ballards, and Peter can talk a little bit more about this, but the owner is happy to cooperate and to install anything that will, make the, reinforce the lot boundaries for the cars being parked there and make sure that there's no one parking on the streets. Peter, would you like to add anything to that?
Sure. I spoke to the owner this morning after hearing the comments, and he's willing to put in the ballards with chains to the so we could delineate exactly where the property line is, so the cars would not encroach within the sidewalk. So he's willing to do that.
And that will be the owner's responsibility?
Owner, the tenant, it'll be done, whether the cost is from the owner or from the tenant, they'll work that out amongst themselves.
Okay. And who generally operates and oversees the site that is compliant with all the regulations? Who's responsible?
I believe the tenant will be responsible, but they have to work hand in hand with the owner to make sure it is enforced.
I see Commissioner Shetter's hand is up.
Thank you, Vice Chair. I just wanted to correct the record for a statement that Ms. Lanson made. The community board didn't approve the application unanimously. There was just one vote against the approval. Just wanted to correct the record for that.
Thank you. And another comment that the board had requested was there was a question from Commissioner Shetta about a car without a license plate on it. And so we had asked the tenant and the owner, and the car that had no license plate belongs to a dealership. There's no cars being sold on the site, but the auto repair shop does occasionally fix cars that belong to a dealership.
Okay. Commissioner Shibata, are you okay with?
think it was Shabeta who said that, Commissioner.
Yeah,
Yeah,
Shibet.
I'm okay.
Sorry. Okay, and then finally, there was a question about the seller and who uses the seller and what is and who has access. So the seller is used by the tenant of the auto repair shop because it holds their compressor in the cellar. And I believe that it is accessed from the outside of the premises. There is only one way to access it. There's one mode of access, and Peter can probably address that better.
Correct. If you look at the plans, you'll see there's a sidewalk, there's a cellar door that leads to that portion in the cellar. It's actually along the Avenue L side, and that's the only access, and it hasn't changed. That's been the existing access, and that's as it was going back.
Yeah, I see it in the previously approved plan also. Okay. Can you add a note to the plan that so it's only used, so does that raise any hazardous issue? The compressor is below?
And it's below grade and there's, means a secondary egress or something?
Yeah.
Maybe fire department, I don't know.
We're looking into that.
Okay, let Ms. Landsman answer that question, please.
Oh, I was just going to say we're happy to look into that. I'm not sure. I believe Commissioner Sheta was about to say something.
Yes.
My concern is not whether they're gonna store a compressor or any other equipment. I first of all, I don't think a compressor would pose like a threat, but the concept itself, using the cellar as a storage for the mechanic shop, I'm not sure about how legit is that. Regarding the cars with plates, this is a photo taken, I believe 2021. It's a Google image. There is 1, 2, 3, 4 cars. So it sounds like that, and actually this is the 5th one. There is no plate on that. So these 5 spots that supposedly used for storing cars that being repaired are used for repairing cars, maybe for a dealership, maybe they are indicative of a car sale on site. I buy your feedback saying that there is no car sale. I got that, but the 5 spots that supposedly secured on site should be used for cars that coming for repair from the public, not from a dealership. This facility supposed to serve the public of the neighborhood. Just wanted to make this clear. On the cellar access, if it's not used to store hazardous material, if there is no physically change to the access to the cellar, if the board would allow that, I'm fine with it. I mean, for me, it's not a big deal. What I was concerned about, and this is the reason I raised the access issue, I was concerned that the access is made from the mechanic shop, and it was kind of like a structural modification to the cellar walls. That was my concern, and that's why I raised this.
Okay. All right. So I think what I want a clarification for the record, since it has been raised. If you can clarify whether all throughout the cellar was used for automotive storage purposes or not. And if you could clarify that. And since it does not raise, and it's in pre-existing condition, and that addresses Commissioner Sheta's question of structural, you don't need to respond to it. Since it has been on the record, I just want you to clarify whether it has always been used for automotive related use or not. With regards to the use of the parking area for storage of auto repairs, the zoning resolution doesn't distinguish whether the auto repair is for public or whether it's for a dealer. It says it's a auto repair facility. It does. Now, I understand what you're saying, Commissioner Sheta, is it working exclusively? Is it an offshoot or is it an offshoot of the dealership that is just serving the dealers? the zoning resolution, even if it were to be the case, it would still come back. I mean, even if, let's say, it was to be a facility just for the dealers, the zoning resolution doesn't have a separate section. Auto repair for dealers versus auto repair for public. It's the same. Auto repair is auto repair. And so I am not comfortable putting the board in a situation where we have to go and supervise and make sure what percentage of the cars are from auto dealers and what percentage of the cars for public. The key thing is that regardless whether it's an auto repair shop that is facilitating cars mostly from the dealers, or whether it's an auto repair shop that is serving the public, it should not be an impediment to the pedestrian circulation. It should not be an impediment to the vehicular circulation in and around the block. And it should be respectful of the neighborhood in terms of the sidewalk and not encroaching on the sidewalk and not doing any repair work on the parking lot. So that will be constant. So I don't think we can impose that. And I do not think even if we were to impose it, there is no way to oversee it. So the key thing is it's an auto repair use. You're here, it was before a variance, and so neighborhood character, traffic circulation, pedestrian circulation has to be addressed. And that's why we are asking for the operational plan. So when you do prepare the operational plan, you need to respond to us how the number of parking spaces you have on site can be maintained without it encroaching, because you're going to move cars in and out. It's like a jigsaw puzzle, right? And when you're going to move these cars in and out, it reminds me of that little square game, with the blue car, red car, who is behind whom kind of thing. You are going to, at some point, be encroaching onto the pedestrian sidewalk. You will be moving cars out. You will double park. The question is how you're making sure you're not doing those things. You need to make sure in your operation, you are not encroaching onto the pedestrian. You're not like pulling a car out, putting it on the sidewalk while you're moving the cars inside. Or you're not pulling a car out and putting it on the sidewalk, double park, affecting the traffic flow. Those are the things you need to be responsive and be mindful of in your operation maintenance of the site. And it's not, and please, when you do write it, make sure it is implementable. And it can be implemented. So do identify the staff who will do it. If you need a camera or if you need something that will constantly monitor that, please include those into your statement and operational plan. Because one of the things I will ask our compliance officer to do is should we grant it, make periodic site visits to make sure it is in compliance with the operational plan that you have stated. Otherwise, because that's a critical part of the variance that was granted, neighborhood context.
Absolutely. And then finally, there was a comment made about the whether the curb cut and whether or not that driveway was shared. There is no shared driveway. The curb cut is over our property, and then the adjacent residential property has their own entrance inside and driveway that they maintain on their own.
Okay.
At their own time. And as far as the trash, we have reiterated to the owner that the trash needs to be put away. There should be no tires on the street, and the owner will make note of that in the operational plan and make sure that there's no debris outside next to the trash, unless it's ready to be picked up that evening. But there will be nothing outside after closing hours.
I think from the Google Street View, I haven't done a site visit, but from the Google Street View, it seems it wasn't just the excess trash. It was basically excess material of the building supplies that were stored there, like tires were stored outside. There were other wood and other pieces of material that were stored there, which kind of comes in handy for your work. I don't think that is not the purpose of that parking lot. It is not meant to be the storage yard. Those need to be stored within the site, within the building. I'm sorry. So
I did I did speak to the owner about that, and he mentioned that those items were to be picked up by the trash that night. So I basically told him not to put it out until that night. Leave it inside until it's garbage pickup night, and then take it out at that point.
Okay. Well, what I did ask for is perimeter photos. So please do provide perimeter photos indicating that what is a normal perimeter site condition, and also should provide photos of the interior of that automotive repair building. Sorry, Madam, Ms. Matias.
I know, I believe the applicant said they are going to place bollards. Did he mention no parking sign? We had stated there should be a no parking sign.
Yeah, I did speak to him about that as well, and he was willing to do that. He was going to talk to the tenants to make sure they followed those guidelines.
So that's an easy fix. You can put that up right away.
And then the lighting notation, do you want it as a condition or a plan?
Right. So even though you do not have lighting on site, should there be a change in the tenancy and should a tenant want to put lights up, I just want to have a sign there saying that should a light be put outside, that the lights need to address, the language that I've said should be respectful of the neighbors. It should be pointed down. It should not be casting light into the neighbors. The language will be provided by the project manager. I don't have it handy with me right now, or I can read it out. Give me a second. All lighting sources that are located on the lot line adjacent to residential uses shall be shielded from direct view and to minimize any adverse effect on surrounding residences. Okay.
On a sign on the property, or do you want them that annotated on the board grants, or I just want to clarify.
I couldn't hear you, Ms. Lansmell. You broke up.
Sorry, I just wanted to clarify that you want that statement on a sign on the property line, like in view?
Just
or
on the plan. On the plan.
on the plans. Okay, great. Yep.
Vice Chair, you're breaking up also, so.
Oh my.
We're doing great, Vice Chair. We're doing great.
Don't jinx me. So I think a lot is riding on that operational plan. So please do talk this out with your tenant and the owner very thoroughly and make sure whatever is going to be put there is going to be implementable and is being implemented from the time you issue it, and provide photos of that. We will have our compliance officer go there while currently and subsequently after we approve it, should we approve it. And there was one question I had.
We had the driveway, we had the compliance chart.
And the bollards, just provide some samples of what kind of bollard and chain system you're going to propose. And I think it also, like, I know you may have to move the bollards around because you do, so indicate which bollards are movable, which are fixed. You may need some combination of fixed and movable because you have a tiny lot, I recognize that. So indicate which ones are movable and fixed. And any other questions from the commissioners? Okay, all right. Let's go to the.
No car repairs on the street. We said that already, right?
Yes,
No
yes, that is part of the operational plan. No car repairs on the street. And if you're, you really should not even be using the side street, curbside parking to hold vehicles for repair. That's actually unfair to the residents who are there, who look for on-street parking, and for the commercial tenants along that block. So be respectful of them and their needs so that you try to contain your supply within the site. So do respond to that also. Any other questions from the commissioners?
No,
Okay, let's
regarding the no repair, no repair on streets nor on sidewalk.
Yes, add a note to the plan, and that would be also part of the condition.
Yep, thank you.
No
Actually,
repair on the street and,
repair outdoors is not permitted. So.
yeah, no outdoor repairs permitted.
Thank you, Carlo.
Okay. Do you want to go to the public, Madam?
Okay, yes, let's go to the public.
So the case we are currently discussing is 33790BZ, 1415/17 East 92nd Street, Brooklyn. Should you wish to discuss, please dial in 646-558-8656. You will enter webinar ID number 853-4000-0736 and press the pound sign. At the next prompt, you will then press just the pound sign. Once you're in, press *9 to raise your hand, *6 to unmute to speak. If you're already in the Zoom room, please raise your Zoom hand, and that is the little hand at the bottom of your screen.
Okay. So how long will it take for you to make these corrections to the plan, putting up the sign and preparing the operational plan and making the site compliant?
So we had spoken to the owner before this, the public hearing, and we believe 2 months should be enough for us to create the operational plan, figure out the ballot samples and send them over to get approval from your end, and handle discussions with the tenant to make sure that all of the operational requirements are followed.
Okay.
Vice Chair,
Yes.
Chief Daly's hands is up.
Oh, sorry. Sorry, Chief Daly.
Thank you, Madam Vice Chair. This is Deputy Chief Inspector John Daly with the Fire Department. Comments were made earlier regarding the location of a compressor in the cellar. Such compressor is permitted in the cellar. The Fire Department has no objection to that. In addition, this establishment are current with their Fire Department permits with respect to the use in storage of combustible liquids at grade. And they also have a permit for one 275-gallon tank above ground. Also permit is current. So the department has no objection to this application.
Okay.
Thank you.
Okay, thank you. Thank you very much.
Perfect.
All right. So you need 2 months to provide the operational plan and a ballot sample and the revised plan also.
I believe so. Peter, chime in. You're on mute.
Sorry. Am I there?
Yeah, you're there.
Okay. I believe 2 months should be ample time to satisfy the board.
Okay. All right.
Thank you.
Thank you very much.
Thank you.
Thank you.
May we move on, Madam Vice Chair?
Yes. Yes.
Item number 19-2016-4176BZ, 7804 31st Avenue, Queens.
All right. So who will be representing this case?
I don't see Lisa back in here. Frank St. John.
Josh Rhinesmith is the applicant working on it, but maybe Lisa.
I have Lisa. I don't have Josh. There's Lisa. Hi, Lisa.
Hello.
Anyone else with you?
No, just me.
Okay. Do you affirm that, raise your right hand, do you affirm to tell the truth, the whole truth, and nothing but the truth in your testimony before this board and to respond honestly to board member questions?
Yes.
Go ahead, Mr. Antia.
So this is an extension, a request for an extension of time to obtain a C of O for a house of worship. The building is about 80 to 85% complete by the end of July. The reason for the delay in completion is the city moratorium on non-essential construction that began in March of 2020, and that had interrupted the construction that started in July of 2019. The work that remains to be done in order to get the TCO is primarily finish work, and that's why additional time is needed.
I don't have any, yes, Ms. Prenga.
I believe this is also an application to extend the time to complete construction in addition to the CO.
Yes, that's correct. Thank you.
Right.
Thank you.
Let's, any comments, any questions from the commissioners? Shaking their heads, no. Let's go to the public.
So the case we are currently discussing is 2016-4176 BZ, 7804 31st Avenue, Queens. Should you wish to discuss, dial 646-558-8656. You will enter the webinar ID number 853-4000-0736 and press the pound sign. At the next prompt, you will press the pound sign. Once you are in, press *9 to raise your hand, *6 to unmute to be able to speak. If you are already in the Zoom room, please raise your Zoom hand, and that is the little hand at the bottom of your screen. 10.
So we have nothing, we don't need any submission on this. I don't see anything.
No, we just want to clarify the delay in the TCO.
Right. And
you all wanted some correction to the resolution, but I'm assuming we'll do that during the preparation of the.
Yeah, I think it was missing in the statement of facts, so we can correct that in our resolution, that what the board had approved was a variance and not a special permit, and that it's a 3-story plus cellar building. Somehow the statement of fact didn't refer to that, so I just want to make sure we wrap up the entire building from cellar all the way up, and that can be reflected in our resolution. So is 1 minute up?
Yes. I have 2
So
minutes.
since we don't have any submission, we will try our best to put it on for the earliest hearing for to vote it. Maybe September, if not definitely October. We will try to get it done in September because you need this to get the DOB process going, right?
Yes.
Okay, so we'll try to get this in for September. Is it possible? Miss Matthias, Mr. Costanza?
Yes.
Okay, all right, we'll put this on for September then.
Thank you.
Want to make a motion to close, Vice Chair?
Motion to close, yes, thank you. Thank you for reminding me. Motion to close.
Vice Chair Chanda?
Aye.
Commissioner Otley Brown?
Aye.
Commissioner Shepherd?
Aye.
Commissioner Shabeta?
Aye.
Commissioner Yoon?
Abstain.
Okey-doke.
Right. Thank you, Mr. Rantia.
Thank you.
Sorry, Mr. Rantia. May I go on, Vice Chair?
Yes, please.
Appeals calendar continued hearing items. Item number 20, 2020-58A, 2020-59A, 1012 Jasmine Way, Staten Island. This is the leasehold there.
Hi, I should also have a Roger Moraes. If he's not here, I'll text him. Yeah, he's in.
I don't see it. I don't see it in the participant room.
Oh, I see him. He's on mute.
Oh, there he is. Okay. Hey, stranger. Want to unmute, Mr. Rossi? Unmute. Okay.
We see you, Roger. Just need to unmute.
Got it.
If
Got
you-
it.
Thank you. Raise your right hand. Do you affirm to tell the truth, the whole truth, and nothing but the truth in your testimony before this board and to respond honestly to board member questions?
I do.
I do.
Elise Fuller, sorry.
ahead.
Elise Fuller from Eric Palatnik PC. I'm here with Roger Moraes, who is the architect working on this project. As you pointed out, we have been in contact with the fire department about getting an approval, and Roger's here to tell you an update on that quickly.
Okay. Yes. Good afternoon, Vice Chair Chanda. I listened to the review session earlier, and so I had communication with the fire department last Tuesday via email, and so I expect an approval or soon. It's under review right now, and I know that the fire department was inundated with work, so it sounds like they've gotten to the job and are reviewing it now, and hopefully it should be approved shortly.
And then we can finish all those other comments based on that approval. We can finish the response to DEP.
Right. How long will the whole thing take? Once you get, how long will it take for FDNY to sign off? Can you project?
Well, so the captain from the fire department emailed me last week, and so I responded to him. I haven't heard back from him since, but I assume if I can get in touch with him this week, maybe he can issue an approval next week or the week after, and then it has to go to the civil engineer to get the paving plan approved, and maybe a few weeks for that. So maybe 6 weeks in total, something like that from now, possibly.
Sorry, go ahead.
We could speak to John once we open up the record for.
Right, so let's go to actually public hearing. I expect no comments from any of the commissioners. Okay, so let's go to the public hearing. And we will hear from our Chief Daly.
Okay, the case we are currently discussing, you want to change the screen, Steve? Thank you. The case we are currently discussing is 2020-58A and 2020-59A, 10 to 12 Jasmine Way. This is the GCL 36 for 2 single-family homes. You can dial in 646-558-8656. You will enter webinar ID number 853-4000-0736 and press the pound sign. The next prompt, you will press pound sign only. Once you are in, press *9 to raise your hand, *6 to unmute to be able to speak. And if you're in the Zoom room already, please raise your Zoom hand, which is the little hand on the bottom of your screen.
Okay. All right. I think we have Chief Daly here.
Thank you, Madam Vice Chair. Deputy Chief Inspector John Daly. I am meeting with Captain Malloy of the City Planning Unit, who's reviewing this application on Wednesday, and I'm hoping to have the letter either completed by late this week or early next week, and to send over to the applicant.
Thank you.
Thank you very much.
All right. So then how long will it take, Ms. Fuller, for you to get all the other follow-up sign-ups?
I think that his 6 weeks was good because I then don't know how long DEP needs to review it.
Okay.
So I would keep that projection, I think.
You would still need that. Okay.
Yeah.
So the 6 weeks included everything.
Hope so. Yeah.
Okay. All right. So I guess we still need all that sign off. We can't close until then.
Unless you want to, but I wouldn't.
No.
I wouldn't suggest you do.
Yeah. So let's keep it open. We'll close, and if there are any corrections or anything that needs to be made to the plan, those need to be reflected in the plans.
Mm-hmm.
Okay. So I guess 6 weeks means October, end of October.
Yeah, I'm assuming I'll get either end of October or November.
Yeah.
We'll get back to you on that.
Yeah, thank you.
Okay. May I move on?
Yes, please. Thank you. Thank you, Ms.
Thank you.
Fullader.
Appeals
Thank you.
calendar, new,
Thank
I'm
you.
sorry. Thank you, Mr. Marassi. Good to see you.
Yes.
Appeals
Thank you.
calendar, new cases, item number 21, 2021 79A, 3860 11th Street, Queens.
Okay, Madam Vice Chair,
Yes,
would you want to hear the statutory vesting first? Is that, or just keep it in the order?
let's keep it in the order because
The notes
that's how
will
we
get,
have it on the schedule. But I mean, let's keep it in that order because that's where we have in the review session the notes also.
Very good, thank you.
Okay. All right.
okay, I have Alexis Landsman on this and who else?
Richard LaBelle should be joining.
Okay. Okay. Okay, that's it. Richard and Alexia? Okay, raise your right hands. Do you affirm to tell the truth, the whole truth, and nothing but the truth in your testimony before this board and to respond honestly to the board member questions?
I do. All right. Hello again, commissioners. We have attended the executive session for the common law vested rights portion of this application. And we are going to discuss with the applicant to see if they'd like to pursue the common law application, since we've heard the comments for the statutory vested rights application as well. And depending on where we want to go with this common law application, we will provide additional photos of the foundation as was requested. We will clarify the losses associated with making the building compliant. And we will revise the affidavit and statement accordingly. At this moment, I think we'd like to pursue the statutory vested rights application. And so if we want to move forward with that application, do we have to be re-sworn in?
Okay. Yeah. But do we have to go to public hearing for this or do we do one joint public hearing?
No, you'd have to, you want to go to the commit, you want to go to the public now? Let's go to the
Well,
public.
that's a question technically. Do we have to go to the public hearing for each one or do we go to public hearing for both together?
We have to go to the public for
Public,
each one. since we're
each
calling
one.
it individually.
Okay, let's try to put up the screen and wait for the public.
Oh, there's.
In the meantime, are there any questions from the commissioners on this one, the common law?
No. Okay, the case we're currently discussing is 2021 79A 3860 11th Street, Queens. Should you wish to discuss, this is a common law vesting application. Dial 646-558-8656. You will enter the webinar ID number 853-4000-0736 and press the pound sign. At the next prompt, you will only press the pound sign. Once you are in, press *9 to raise your hand, *6 to unmute to speak. And if you're in the Zoom room already, please raise your Zoom hand, which is the little hand on the bottom of the screen. And to respond to your question, Ms. Landsman, it's an A case, so you're not required to be sworn in on the vesting cases.
Vice Chair,
Yes,
just clarification. When it says we will revise the statement, if the intention is to defend the idea that the entire building and the entire foundation system need to be removed, I would need a copy of the structural drawings. I don't wish to go to that scenario. Even if you mentioned that you need to redesign, I would buy that as a loss. We don't need to debate about whether the foundation system could be repurposed and reutilized for a different use. I would caution the applicant that, for example, if I do have a building and I want to change from commercial use such as a hospital and switch it to a same configuration building, I would say, with same number of floors, with same exact configuration, but the only thing that's going to change is the use. According to the building codes, the racking loads, the life loads are less for the residential. meaning that you could take the foundation system and repurpose it and reuse it for a residential use. I don't want to go
Excuse
to
me,
that.
this is an M1. I just want to correct you. There's no residential as of right in an M1.
No, I'm not talking about this case specifically. I'm talking about general.
Okay.
Sorry. I'm talking in general. If you have a commercial building and you want to use the same exact configuration, but for a residential, the loads according to the building code for residential uses are generally lighter. Don't go there. Just mention it that the foundation system will need to be significantly revised, significantly modified, any kind of language like that. Stay away from total knockdown or total removal of the building and the foundation, please.
Understood.
Thank you.
Okay, we could remove the announcement.
Yeah. So I think you have a pretty clear guidance in terms of how to make that argument, Ms. Landsman and Mr.
Yes,
LaBelle.
absolutely. Yes.
So I think what we are accepting is that in a nutshell, that yes, there is going to be likelihood for redesign, for if you were to repurpose it, those are all acceptable, and losses and time incurred are all acceptable. Don't go to the extreme. Stay within reason.
And even design fees as well.
Yeah.
Thank you.
And
right.
with
Yeah, go ahead.
Yeah,
Ms. Landsman had a question.
Oh, no, I wanted to proceed with the statutory vested rights. Tony, please.
No, that's what I was asking, Vice Chair.
No, you please do. Please do proceed,
Yes,
Matthias.
Item number 22, 2021 81 BZY, 3860 11th Street, Queens.
So with regards to the comments on the statutory vested rights applications,
I'm sorry, can just state your name again for the record?
my name is Alexia Landisman. I'm accompanied with Richard LaBelle from Sheldon LaBelle PC on behalf of the applicant.
Thank you.
Thank you, Prabhu.
So with regards to the statutory vested rights application, it sounds like we have met the findings, but we do need to provide clarification on the financials. And regarding Commissioner Otley-Brown's comments, we are happy to remove all of the expenses that are not regarding the cost of construction from the financials, and we will resubmit those accordingly. Additionally, we wanted to clarify that the provision that we are using is section 42-111E, and we can revise the statement to reflect that section. And
And are you using the tolling? Is the tolling in effect?
Perhaps I can talk. So thank you, Vice Chair. So 42-111E simply refers to the requirement that the applicant have received building permits for development of the transient hotel prior to April 23rd, 2018, which they did. So 11332 is available through normal channels, which would have required that the foundations be finished by 12/2018. The tolling, well, not the tolling provisions, but the vesting provisions in the actual special permit section of 42-111 are more favorable. As was stated by the Vice Chair and by Commissioner Otley-Brown, they allow you to move the date to December 20th, 2021. And given that the application here was filed prior to 30 days from that date, we then now are allowed to refer to that for our 11332 date. And so the 2 years, would apply from that date, which is essentially, as Alexia has intimated, should be sufficient for the applicant here. We will talk about that with them, but basically no tolling is required. We don't even need to refer to tolling because we met all the dates within 42-111E.
Okay. Okay. All right. Okay. Any comments from any of the commissioners? Okay.
I'm sorry, Commissioner Sheta had a comment, I think, about the affidavit had the wrong lot number. or lot number?
Yeah, we'll clarify. I believe
Clarify that.
the affidavit, the block and lot differed from that, and the statement of facts we'll correct that on resubmission.
Because I know I had it corrected, maybe we need to correct it again. Okay,
Thank you, Tony.
okay. Okay, do you want to go to public on this too?
Yes, let's go to public on this.
Okay, so the case we are currently discussing is 2021-81 BZY for the address of 3860 11th Street, Queens. This is an extension of time to complete construction. It's statutory vesting application. Should you wish to discuss, dial 646-558-8656. Enter the webinar ID number 853-4000-0736 and press the pound sign. You will also, at the next prompt, press the pound sign. Once you're in the room, press *9 to raise your hand, *6 to unmute to be able to speak. And if you're in the Zoom room already, please raise your Zoom hand, which is the little hand at the bottom of your screen. It's 2:29, okay.
How long will it take for you, Ms. Lansman, for you to respond to the comments?
So I believe we can be able to respond in 2 weeks' time for the statutory vested rights, and also speak with the applicant and let you know how we like to proceed with the common law vested rights application as well.
Okay.
We were hoping to be able to close today so we can provide that, all that information before the decision hearing, if possible.
Yeah, I think we had met the statutory vesting. I mean, we all agreed that you were there. You just needed to clean up the documents, and even with the revisions to the financing, you would meet that substantial construction portion of it. I would be okay with closing it. Are the commissioners okay with closing it? Yeah, okay, all right.
Yep.
Anybody has a question? Did I hear someone say,
A point of order on the, I'm sorry, if you're closing this one, on the 2021-79A, the common law, do we have to close that one also?
No, that would remain open.
That would remain open. Okay,
Correct.
just point of clarification.
And before any potential close, I'm sorry, before any close, we did want to join the rest of the development community and congratulate Commissioner Yoon on her appointment.
Thank you. Thank you so much.
Okay.
so let's, since we do not have anybody calling in, so motion to close and your 2-week submission. I hope we have enough space in the September hearing. If not, it will be October. We'll do our best. We will get back to you, but please do submit as soon as possible.
Understood. Thank you.
Thank you, Vice Chair.
So the motion to close, Vice Chair Chanda,
Aye.
Commissioner Otley Brown,
Aye.
Commissioner Sheta,
Aye.
Commissioner Shabeta,
Aye.
Commissioner Yoon.
Abstain.
Okay. Too many papers, sorry.
Okay. Thank you.
I'm sorry. May I go forward?
Yes, thank you, Ms. Lansman.
Thank you.
Mr. Lopez.
Have a nice day. Thank you very much.
Bye.
The next item is item number 23, 2022 1BZY, 1227 Broadway, Manhattan. This is also an extension of time to complete construction, a statutory vesting application. This would be
the
Eugene
Kramer
Travis.
legislation. Who should be, who's representing?
Eugene Travers, as far as I'm aware of.
Do we? Yes, I see Mr. Travers.
Yeah.
Hi, Eugene Travers with Kramer 11 for the applicant. Stuck in
No one
the,
else is with you, Mr. Travers?
it's just me today.
Okay, please state your name for the record and proceed.
Okay, Eugene Travers with Kramer 11 for the applicant. I listened to the review session comments. I just wanted to respond briefly. to the community board comment. So 11.332A provides for 2 extensions of 2 years each. We're applying for our first extension with this application. 11.332B allows for additional extensions of 1 year each, but in order to access 11.332B, that's where you have to demonstrate that you're prevented from getting your certificate of occupancy during those first 2 extensions due to some hardship. That's where the considerations of public safety come into play. So this application is not there yet. It probably never will get there given the amount of construction that's been done. So this 11.332B does not apply here. We did send a letter to the community board to clarify that. It appears that they chose to disregard it, which is fine. But I just wanted to clarify that for the record.
Thank you. Any questions or comments for Mr. Travers from the commissioners? Okay, let's go to the public.
Okay, the case that we are currently discussing is 2022-1 BZY, 1227 Broadway, Manhattan. This is a extension of time to complete construction. This is a statutory vesting application. Should you wish to discuss, please dial 646-558-8656 and to webinar ID number 853-4000-0736 and press the pound sign. At the next prompt, you will press the pound sign, just the pound sign, and then once you are in the room, press *9 to raise your hand, *6 to unmute to be able to speak. If you are already in the Zoom room, please raise your Zoom hand, which is that little hand at the bottom of your screen.
Mr. Trevor, you said that you had responded to the community with that statement. Did you submit that into our file?
I thought we had. If we had not, yeah, I thought we did. If we had not, I'm happy, of course, to submit that.
Okay, yeah, just for our record, if you could do that.
Certainly.
Actually, Ms. Matias would let you know if we don't have it. Please resubmit. Please submit it.
Will do.
No need to submit if we already have it.
Understood.
Yeah, so, okay. And how far are you on the TCO? You said you're waiting for a walkthrough, right? It's
Yeah, I believe the applicant's still waiting for a couple of inspections to wrap up, but it takes time to get these things completed.
okay. All right. So there's nothing to submit on this. So once the 1 minute is up, I will recommend that I don't know if anybody from the community board will want to speak on this. I'm just waiting to see if anybody from the community board or community would want to speak on this. Is the 1 minute up? 2 minutes?
Not quite yet.
Not quite? Okay. Our September schedule is very full. We will do our best to put it on for September hearing. Is that possible, Mr. Costanza?
Yes, and the previous one as well has been put on in September.
Okay, both have been put for September.
Correct.
Okay. So, okay.
We're good.
Right. I think we have put in enough time.
Yeah, we're good.
Okay, thank you all very much.
Okay, so we have nothing to, you have nothing to submit. So we're going to close. Motion to close.
Vice Chair Chanda?
Aye.
Commissioner Otley Brown?
Aye.
Commissioner Shetta?
Aye.
Commissioner Shabeta?
Aye.
Commissioner Yoon?
Abstain.
Okey doke.
Thank you very much.
Thank you, Mr. Trevor.
Oh, sorry, 1 sec. Too many papers. Zoning calendar, continued hearing items, item number 24, 2018, 173BZ, 128 Beach 9th Street, Queens. This should be Mr. Goldstein and or Miss Rose, I'm not sure. With that one.
Good afternoon.
Yourself?
Barbara should be with me.
Oh, Barbara Cohen, yes, I'm sorry, thank you.
And Shmuel Flam, the architect, may, but I don't think he needs to speak. So if he's here, he can swear in just in case, but I don't think he needs to speak.
Barbara's here, Jay. Shmuel is, I don't see him. Flum, is that Flum?
Flam, yeah.
I don't see him, is he in?
Okay, we can proceed. If we need him, we can swear him in after, I guess.
Barbara, do you want to unmute, please?
Yep.
Thank you. Do you affirm, raise your right hands, do you affirm to tell the truth, the whole truth, and nothing but the truth in your testimony before this board, and to respond honestly to board member questions?
I do.
Yes.
Please state your name for the record and proceed.
Good afternoon, Jay Goldstein for the applicant. I'm with Barbara Cohen today on behalf of the applicant as well. I don't know if Barbara wants to state her name herself, she can. As a preliminary matter, I just want to wish the outgoing chair all the best in the next steps of her career, and welcome Commissioner Yu to the board, and I look forward to working with you.
Thank you.
So we heard the board's comments, we attended the review session. I think I'll let Barbara speak first with regard to Commissioner Ali Brown's comments, and then I'll proceed.
Sure. I have to say I wasn't totally sure what the question was, but in terms of the cap rate, we do use the realty rates as a guide. The prior report used 5.7. This report used 5.3. The quality of the projects got better. I mean, the smaller the project, less risk. So the expectation would be lower in terms of return. The development costs equivalent to the capitalized value is equivalent, which represents the minimum variance. I actually went online to look up, some of the other sort of reports on cap rates. It certainly falls within the ballpark. And the realty rates for the first quarter of 2022, the minimum was 5.24, the average was 8.04, maximum at 12. So I'm not sure actually what the issue was.
Hello.
Hello.
I was just, I said that was literally the only thing I wanted you to do was justify your 5.3 cap rate, given that many residential developers are willing to accept lower cap rates for 100% residential projects. That's all. I expected pretty much what you said, and also probably something about the location in Far Rockaway, Queens operates more like a suburban area and not like the New York City metropolitan area, and so therefore a little bit riskier. So I answered part of it for you, you answered the other part, and we are good.
Terrific, and I'm very happy you love the report otherwise. So very good, thank you.
Okay, thank you, Barbara. So to the other comments, just for a point of clarification, there was no DEC approval. Prior to the beginning of the application, prior to coming to BSA, we went to DEC. We had conversations with them, and it's been a perpetual chicken before an egg situation with this case. DEC said, go to BSA. BSA said, what's the status of DEC? So we've gone back to DEC, and we're part of that process. DEC's asking questions about flood zones, which didn't play in back then. That said, a lot of the reason for the delay on this case has been there are an extreme number of moving parts with different government agencies. I believe that, and Commissioner Shada, to your point, very happy to condition the grant on, or make note in the grant that it's not waiving any of the DEC, DCP, DOB rules and regulations, because we're going through that process now to show compliance, and we'll have to do that to get our building approved anyways. However, having a BSA approval or a BSA building in hand that we can say, like, here's our BSA building, this is what the building's proposed, and this is how we comply with all of your regulations, will be an extreme help in this situation with all of the other agencies. So, we appreciate the comments, Commissioner Sheta, and we've worked hard on this project, and I apologize for the delay in the project, but it was a very large undertaking, I think greater than most of us thought it was going to be.
Thank you, Jay, for
Yes.
the clarification.
I have a question, Mr. Goldstein, and that is with regards to the approval that you would need from City Planning Commission. How does the approval that we have before relates to that? Couldn't that be done before?
So we're going through the city planning process now for the chair certification, and they've asked us to use the BSA proposal and BSA approval when applying and when they're analyzing the building, because they'll take that building and analyze compliance for their open, for the public walkways and things like that. So again, it will help. We are, pursuing it, but it'll be helpful to have the BSA, here's the BSA building. Now let's go forward and make sure we comply with everything else. Understanding the fact that if there's a change required of us that impacts the design of it or the bulk or the footprint of the building, that we'll have to come back to the board. I think, as you mentioned during the review, we will have to come back to the board, and we understand that, and we're ready to do that.
Right. So I think it can change two ways. One, it either expands out of the scope, then it would be a major amendment. And if it stays within the scope and shrinks, I don't want to speak out of turn, but maybe depending, it could be a letter of substantial compliance. But that all depends on how much within scope and that is. But that we'll have to play it as we go along. But
100%.
I just see that as two possible outcomes of that. But as long as you and your client know that that's what will happen, and you need us first to start the motion. So
we understand that we're tied to the board with any approval anyways. We're happy to work with the board. So any approval that we can have to help push along the other agencies is much appreciated.
And I have to thank you, Mr. Goldstein, for really shepherding and getting everything together. And you heard us, and you were very responsive to all the comments. So really do appreciate it. It makes things go very smoothly. Thank you.
Thank you very much.
And so are there any other questions from the commissioners? Commissioner Sheta.
Yeah, thank you, Chair. Yeah, Jay, thank you so much for getting this done that quickly. I believe this is the second time I see a variance during the past 5 years done in 2 hearings. Well done. The second thing, the thing I hate most is to read fine prints. And for me, our resolution as it compares to the drawings is the fine print. So regarding conditioning this, yes, of course, we're gonna condition that. But I would appreciate adding a note to the plans to make it clear for the plan examiner at the DOB. So our friends, when they start looking at the plans, they're gonna see this. We're not waiving DEC regulations. We're not waiving any regulations relevant to Appendix G in the drawings. Thank you.
No problem. I can have that put on the plans.
Okay. All right, so let's go to the public.
I think Tracy has her hand up.
Oh, sorry.
Hi.
Miss Benke.
Yes, I wanted to know if you know the status of the natural resource analysis, because the EAS just said that there's going to be further analysis being undertaken.
So it is ongoing. I don't have a timeline on it, but it's ongoing with the consultants that we're using for DEC. So I can get a timeline after, but it's definitely ongoing. Something that not many people are familiar with. So finding the proper consultant is, difficult.
Okay. We also we did send the new EAS for noise review. Unfortunately, they are rather backed up at DEP on noise due to staff and workload. So that could take a while.
Right. And
yes, Ms. Prenga, you have your hands up.
Hi. I raised my hand because in relation to the note that Commissioner Schetzer requested, we have a note in our guidelines for properties in flood zones. And it reads flood regulations, including Article 6, Chapter 4 of the zoning resolution and Appendix G of the New York City Building Code as applicable shall be complied with as reviewed by the and approved by the Department of Buildings. I know you wanted a note for DEC regulations as well, but would that note cover the Appendix G?
Right.
Yes, it would.
Right.
Okay.
Thank you.
Thank you.
Yeah. So maybe if we don't, I mean, we don't deal with DEC that often. So maybe we can draft a note internally and circulate and make sure it's correct. And then we will share that with Mr. Goldstein.
No problem.
Okay.
All right, let's go to the public, please.
Okay, the case we are currently discussing is item number 24, 2016, I'm sorry, 2018 173BZ 128 Beach 9th Street, Queens. This is a variance for a mixed-use development. Should you wish, I'm sorry, it's a residential development, sorry. Dial 646-558-8656. Enter webinar ID number 853-4000-0736. Press pound. At the next prompt, you will press pound. Once you are in the Zoom room, press *9 to raise your hand, *6 to unmute. If you are in the Zoom room already, please raise your Zoom hand.
Okay. So there's not much that needs to be corrected in the plan, but the real big holdout are all the SECRA approval. We cannot close until we have the SECRA sign off.
Correct.
And are we allowed to close pending? Secret is not
No.
part of our findings. No?
No.
Okay. Understood. Okay, understood. Well, I mean, obviously, my adding the notes to the plans is quick, but if we're not pending secret, I think we need somewhat time on the hearing, which I think
Yeah.
we're happy about anyways.
Yeah. Yeah, so I think it's going to be, I mean, you're still trying to figure out the natural resource, so.
No, we have someone working on it, but it'll take some time. So, what, I don't know, November, you only have November 14th.
Right.
I
And
think we
then
can,
December 5th.
December 5th, I think should work. And I'll hopefully have it by then. That'll give us almost 4 months to have this done.
Okay. But you will have the natural resources done before that, well before that.
Well, I'm saying I'll have it before that, get it to DEP, and hopefully we'll have the ability to get that signed off before the December
Yeah.
here.
December. Yeah, I think December is probably more realistic.
Okay.
Okay. We didn't have anybody join in for testimony. So any other comments, questions? None? Okay. Thank you, Mr. Goldstein. Thank you, Ms.
Thank
Cohen.
you so much.
Okay, Jay, you're going to stay on?
Yes, I'm on.
Okay, item number 25, 2019 277BZ 8104 166th Street, Queens. Do you affirm to tell the truth, the whole truth, and nothing but the truth in your testimony before this board and to respond honestly to board member questions? I'm sorry, I meant to ask you by yourself.
I do, I'm by myself.
Okay.
Good afternoon, Jay Goldstein for the applicant. We thank the board. We attended the review session. I'd like to thank the board for their review and their comments and consideration on this case. Just a quick note with regard to the mikvah for clarification. Essentially, we had a choice, keep the classrooms or keep the mikvah. And as we tried to make clear during our presentation, during the other submissions, the mikvah is an incredibly important and essential part of any community. This community does not have a mikvah that is walkable for Sabbath and holidays. And therefore the mikvah, as it was the focus and essential part, So we opted for the mikveh in the cellar as opposed to the classrooms, and we reduced the building by taking out the classrooms at the third floor. It was a choice based on the programmatic needs and the really just to emphasize how important a mikveh is to a religious community where there is no other. So we thank the board again for their consideration. Commissioner Sheta, with regard to your comments, as mentioned by the vice chair, this building will be reviewed and designed for all safety concerns, and it will be during construction, all safety measures will be taken. The neighbors have Mr. Gergoff, who's been the spearhead of this application. They have his contact information, and they are free to reach out to him, and we'll continue to work with them to alleviate any fears or concerns before or during construction, including but not limited to monitoring, crack testing, anything of those natures that become necessary based on DOB review, based on our own analysis, or based on concerns during the construction. So again, the neighbors are free to reach out to Mr. Gergov. They have his number, they have reached out to him, and there has been discussions. And that's the best I can do at this point to assuage any fears.
That's good. Thank you so much for assuring that. I see that the community board back then denied this application, 29 against and 9 in favor. Have you submitted the modified plans to them? And if the answer is yes, did you receive any feedback from them?
With every submission that we make to the board, a copy is sent to the community board.
Yeah.
So everything throughout the application has been sent to them. We have not heard from the community board directly on this matter.
Thank you.
I think, again, just keeping the community, the neighbors appraised every step of the way of the construction would go a long way. And the fact that you have a point person assigned and is already in communication, that is good. So please maintain that. It's, as you know, it's always in your best interest of your client to have that in
Well,
place.
he's available to them and they know how to reach him.
Yeah, okay. Any other questions for Mr. Goldstein from the commissioners? Ms. Benke?
Hi, we spoke internally and feel that the seeker, all the determination should stand as the worst case scenario, but if you could update the EAS based on the new scenario by any decision date, that would be preferred and planned.
No problem, we'll do.
Do we have all the sign off?
Right, it was only an LPC sign off. It was fairly simple, and so I think that should not change.
Okay.
Okay, so we can close it then. Okay.
Yes, it wouldn't affect, not close.
Let's go to the, thank you, Ms. Benke. Let's go to the public.
Yeah, Madam
Okay.
Vice Chair, just in the interim, timeline.
Well, can I call the public first?
Yes. Go ahead, Tony, sorry.
Okay. The case we are currently discussing is 2019-277BZ, 8104, 166th Street, Queens. This is for the construction of a house of worship. Should you wish to discuss, please dial in 646-558-8656. Enter webinar ID number 853-4000-0736. Press the pound sign. At the next prompt, you will press the pound sign. Once you're in, press *9 to raise your hand, *6 to unmute to be able to speak. And if you're in the Zoom room already, please raise your Zoom hand, which is that little hand on the bottom of your screen.
Okay, so as Mr. Costanza reminded us, let's talk about the timeline. So we have a secret up, we can close, but how long will it take for you to make?
I could do it this week. If at all possible to get on for September, I could do it this week.
Mr. Costanza? Is it possible?
Yeah, I'm okay. I'm
September 12th?
going to defer to council on this one, just because we just added a few. I think we should be okay, but I don't know how long of a transcript this is for them to decipher.
We should be able to handle it. And I'd just like to note that we have members of the public with hands raised in the waiting room.
Oh, we do? Oh, I'm
Yes.
so sorry.
I don't see them. Oh, I
Yeah,
see.
I don't
Attendees, sorry, I apologize. I do see 3 people.
Okay, who, do you see?
You're letting them in, Chase? Okay, please unmute. Please accept as panelist. Mr. Forrestal, Mr. Yu, and who else is, we'll take one
Yeah,
by one.
I see Forrestal, you, and that's all. Is there anyone else? Oh, and
Forrest,
we have
2 Forrestals?
Yeah, we have Kevin Forrestal and Jackie Forrestal and Wayne Yu.
Okay.
So I think I saw first Jackie Forrestal's hand up. Should
Please unmute. Can you join as panelist or unmute?
So Miss
Forrestal?
Miss Forrestal, do you want to speak? Okay.
Miss Yu is, I'm sorry, is it rude to?
I'm
No, let's
sorry.
Oh, there we go.
I wasn't- I was muted. I'm sorry.
Okay.
We were given to understand that more than one neighbor has corresponded during this week, and some of them may have responded last night, so you may be a little behind in getting the mail from those neighbors. These were objections to this proposal, and I think before you close, we would appreciate it if you would look at those comments. For us, we're seeing that there's been no compliance with the community facilities text amendment for houses of worship. The synagogue has a main sanctuary, which consists of a main floor and a mezzanine with no walls between them. This is therefore contrary to the statement that the main floor of 98 seats is all that must be counted under ZR 3533 and ZR 2535. The main sanctuary has 140 seats, as shown in the schedule provided by Mr. Goldstein on the room utilization chart. 140 people is shown as the total prayer service occupancy. Next up, we have a 3-page commentary from one of our neighbors who lives in the community. That is one of the items that you probably have in your files coming in. The proposal does not meet the requirements for uniqueness, he said. This is a lot just like any other lot in the community. There's absolutely nothing about it that is unique. We have more questions than answers. Each of the sets of building plans proposed since 2019 has been different. The community has had just a bit more than a week to review the new proposal. We are not professionals. DOB has reviewed none of the plans that have been shown to you. An engineer licensed in the state of New York has suggested that we ask the board about setback because he says that a setback applies to the building and the foundation. That leads us to the question about how plantings required by the zoning resolution will be able to survive on an impermeable cellar roof in the required 2 front yards. We also note that Mr. Goldstein has given us the chain of ownership for the site. We wonder whether the fact that the previous owner holds mortgages on the land affects the ownership shown in the deed. As to the windows that do not open and the presumption that this will limit noise, the plans show an HVAC system on the roof over the neighboring properties. Keep in mind, there are 3 adjoining lots to this property. Another question, due to the depth of the cellar, will water have to be pumped up from the cellar to the level of the combined sewer? How will sprinklers be dealt with? Is a kitchen required to have a window? Granting permission for the project that involves a complete excavation of the width and length of the property without allowing space within the lot for the necessary supports to prevent a cave-in is negligent and ensures both conflict with neighboring landowners and a threat to neighboring properties. Thank you very much for your time, and we hope that this has been helpful to you.
Thank you.
By the
Miss Yu?
Okay. I'm next door neighbor. just next to 8104, the proposed site. Though they reduced the number of floor from 3 to 2, but did not change the whole size of the buildings, the huge size. And they want to build a almost 14-foot deep cellar on the entire lot. So the distance from my house wall and house entrance to the excavation line is only 5 foot. So the excavation is just 5 feet from my door. So we're not, this is very dangerous and definitely endanger my house structure and people living inside. Also, what about the retaining wall requirements? What about the construction fence? Where they put it? The supports to keep my yard from collapsing would have to be in my yard, and I don't want that. I do not give permission for my land to be touched for any reason. So second, proposed building would be almost 87 foot long. They request a side yard variance from 11.4 to only 5 feet on my side. Yard regulations ensure light and air between structures. 5 feet side yard with an 87-foot long wall and 30 feet high roof is unacceptable. I sent a picture to BSA to show where the new building would come up to. And it would shadow my whole backyard lawn and would block light and air from all the houses beyond mine along 166th Street. And also the side yard is too narrow, so they have to install HVAC on roof on my side. And that will create a lot of noise and heat. That's for such a big building. And 3, there is an active common driveway right next to their west fence. They should not excavate the property line to block the driveway. There's a few families involved. And also in any meeting gatherings, floor number 1 and floor number 2 will be joined as one room with a seating capacity of 140. So parking spots cannot be waived. And also, in the residential area, they have a cellar with 14 feet deep. They have 2 toilets, 8 showers, 2 bathrooms, 1 ritual tub, and a kitchen. It's really, can I imagine that? If there is a natural disaster, okay, or flood, what do they do? And also remember, we just had a flood not long ago along 81st Avenue and 168th Street. So I sincerely hope before making any decisions, the BSA board will send someone to look at the site for yourself to see how small the lot is for such a big building on narrow streets. So it cannot be blended into the neighborhood. So thank you for listening.
Thank you, Ms. Yu. Mr. Kevin Forrestal, please. Mr. Forrestal. Unmute yourself, please.
He's unmuted, but we can't hear him.
Okay.
What do we do?
Let's give him a little bit. Mr. Forrestal, can you hear us?
You just muted.
He's connecting to the audio.
Connecting to the audio.
Okay.
Unmute Mr. Forrestal.
Was it *9?
Yeah, can you
Star
get the
6 to unmute? Star 6 to unmute. Okay.
We could display the call-in information. We could ask him to call in if he's having trouble joining by Zoom.
Yeah.
Dial 646-558-8656. Enter the Webinar ID number 853-4000-0736. Press the pound sign. The next prompt, press only the pound sign. Once you're in, press *9 to raise your hand, *6 to unmute to speak. You must be in, he's in the Zoom room, press, and he's got a Zoom hand up.
Um,
What do you want to do?
If Mr. Forrestal is not able to join us, I would suggest Mr. Forrestal send us a letter as soon as possible. Either would like, Mr. Forrestal, can you indicate with your raised hand if you can hear us and you're able, or you're. Okay. While we're waiting. Are we getting any more?
I only see one other attendee, and I'm assuming that's Mr.
Okay.
78359. There's something that's ending 359. Is that Mr. Forrestal?
Right. Do we? I think we lost him, or no? We still.
No, he's still there. There it is.
There.
Okay, he's trying to call in.
Mr.
Unmute.
Forrestal,
Can you unmute?
what's the direction to unmute?
*6.
Please press *6 to unmute, Mr. Forrestal.
Here we go.
Hello.
Hello,
Hi,
is
Mr.
this Mr.
Forrestal?
Forrestal?
Hello, can you hear me?
Yes.
Can you hear me? Okay, good. Thank you. I'm sorry for all the confusion.
No, that's okay, and you'll have unfortunately have 3 minutes to speak, but go ahead.
Okay, I'm Kevin Forrestal. I'm president of the Hillcrest Estate Civic Association, which represents the area, as well as the area chair for Community Board 8. Let me just say, not officially for the Community Board, but we received the application, the revised application, a very short time ago, and the board is not in session, hasn't met or taken any action on it because of the time. As you know, thank you for your consideration of this application. It's been years now that we've been discussing this. It's gone back and forth. New applications have come in with major revisions. I have a great concern that there's several things that have not necessarily have been at the major level as to the height of the building or the expansion onto the community, but there are many issues that seemingly have gone by the wayside that have been lost one way or another. And I would respectfully ask that no decision be finalized at this meeting, then that the staff go back and take a look at the review, all the issues that came up over the years, and see if they have been met to your satisfaction. Clearly, my wife in her testimony spoke about a few of them. I would also like, if you do go forward at some point, the issues of the Department of Building are very serious in our estimation, and I would like, if possible, that you would highlight any of those, that your concerns, and highlight to the Department of Buildings that they and make sure that they take a careful look at this review. I point out that the Department of Buildings review was somewhat different than historically has been. It was taken from the Queen's office and taken to Manhattan, and a very brief analysis was made at that time. There's been many changes made to the plan since then. And lastly, I would point out that I would like to see that the applicant go back and get a building permit, which he never received. This building is illegal. and also to pay for all fines that are still outstanding for about 3 years or so. Thank you for your consideration of my comments.
Thank you. We really appreciate the community calling in and staying so long to listen in and joining and providing your feedback and also sending us letters. We appreciate it. Thank you very much. Mr. Goldstein, you've
Vice
heard the.
Chair. I'm sorry, Commissioner Sheta has his hand up.
Okay. Go ahead, Commissioner Sheta.
Thank you, Vice Chair. I just want to mention that I did look at the latest objections submitted last night, and I did look at the photos, and I want to explain to the public that this agency is not granting a building permit. This is just a discussion to waive some zoning requirements. No one can build on your property or disrupt your property without grant. For example, in order for them to excavate, they need to install something called excavation support system. That this is kind of a wall that ensure that your property is not gonna be impacted by the excavation next door. This system need to be designed by an engineer, submitted to the DOB. They look at it, review it, approve it, and after that, in order for them to start building this kind of wall, they need to get an access agreement if they're gonna use your property at all. Without your permission, they cannot touch your property. So I just wanted to make this clear that the government is not abandoning the neighbors or throwing them under the bus. It's not happening. That this entire building will go to the DOB, Department of Building, will obtain a building permit, and it will be reviewed, and you will have the right to coordinate with whoever is building this building, have him do monitoring during construction, even receive automated emails and updates on the status of the construction, any vibrations, any movements. It's not like if this application is leaving this agency with okay, that doesn't mean that they gonna do whatever. Just wanted to make this clear. Thank you.
Thank you, Commissioner Shada. I was going to state that. Thank you for clarifying that. Mr. Goldstein, you should, as the applicant, the community was saying, there are few things in our zest to, and the fact that we saw a revised drawing, there are a couple of things I overlooked. And one is the landscaping. The landscaping that is proposed, it would be over the cellar. And I want to make sure that what is being proposed can be built over the cellar, because there are few cases that we have seen where it has not been effective and therefore the landscaping was abandoned. So you need to factor that into your design and your structure to make sure that the landscaping that you're proposing can be provided at grade. So if that means providing a section over the cellar indicating the detail of how that would be achieved, please do that.
We did, sorry, continue. I didn't mean to interrupt.
So another is you're proposing chain link fence of 5 foot height, I think. That's what I see. Since it's a residential, the fence should be of residential character. So provide a fence that is more representative residential character, vinyl, probably an opaque fence to reduce the noise, because if there is to be, as the entrance, the side entrance would be to the mikvah, not that there will be that much noise generated from it, but you're better off just providing an opaque solid fence along the side lot line and maybe a wrought iron fence or a similar kind of fencing along the rest of the perimeter to minimize the noise and visual and also provide privacy at the same time. And the third is, yeah, you did add a note, right, about the opaque windows and, right, I see that. The other one is the lighting. I do see the lighting that is being proposed. Just put a note, our new language note, that all lighting sources that are located on the lot line adjacent to residential use shall be shielded from direct view and to minimize any adverse effect on surrounding residences. With regards to HVAC, is it possible to move it to the 81st Street, 81st Avenue frontage instead of?
I have to check with the architect. I have to check. That's where the elevator.
Oh, that's.
No, the elevator doesn't go to the roof anymore. I can check with him and see how that would impact. I think it would further impact the design of the building because you have that double height window.
I see.
So that's listed over there, but we can put a note in about shielding it with the sound attenuation blankets.
Yes. Okay. That's the provided noise attenuation around the HVAC.
Yeah, we can put that in.
And provide this, provide the nature of noise attenuation, like what is the noise attenuation that would be attenuated by the.
Okay.
Do you want to respond to any of the things?
I think most of the comments are comments that they've been raised, that the opposition and the community has been raising throughout, and we've tried to address them with the direction of the board. With regard to the landscaping, we reached out to the board and we got proposed landscaping from Ms. Prenga that this board has recently approved for a similar situation with the seller, but we can give a little more detail regarding that. So it was taken into account, and it is something that we thought about when designing the building. But we'll add the notes that were requested and we can update the EAS as requested.
Okay. And with regards to flooding, again,
So with regards to flooding, again, this property will be reviewed heavily. There'll be SD1 and 2s and BPPs and all of the other reviews that are required in order to get a permit for a building of this nature. So as Commissioner Shetta mentioned, this is going to go through a heavy review now. It's not, the board doesn't grant this, as you know, and we go and put a shovel to the ground. So we will, obviously put together an application that will meet the requirements for a building this size to ensure that there is no flooding.
Okay.
Chair,
yes, go ahead.
yeah, I just want to confirm that that full lot seller is an as of right. If let's say somebody's building a house on this lot and he want to build a full lot seller, this is an as of right construction, right?
I believe so.
So that's the I said this actually to assure the public that we're not waiving anything when it comes to constructing a cellar over the entire lot. So this could have been a house with a 14 or 15 foot deep cellar building over the entire lot. The important thing is not how much you build on a lot. You could build like a quarter lot cellar, but the construction process goes flimsy, unsupervised, not well designed, not well reviewed, and then you get a problem. But you could have a full lot cellar with even way more than the current excavation depth, but it's well engineered, it's well reviewed, it's well monitored, and you do not encounter an issue for the neighbors. And I believe this should be the case on this project. The party that's responsible for assuring that, the parties, I would say, are two parties. The applicant and the owner and whoever is building this is number one, the pillar one. The second pillar is the DOB by looking at this, monitoring this. And for the neighbors, they could be an additional party as well by asking to receive monitoring data for the construction process. So making sure on the flight, on the go, live 24/7, that their buildings are not impacted. And this is very important for them to understand. Thank you.
Okay, thank you. Yes, I think, so if you, in your next submission, just put, I'm sorry, Mr. Goldstein, in your next submission, you will have to revise the plans from what the comments that we, so please revise those and add notes to your comments and in your letter address, just state what we have discussed here in terms of how it will proceed, and the DOB permit and the construction and the responsibility. So that it's on record and everybody's aware of your responsibility, city's responsibility, and how the work proceeds.
Okay, no problem.
So while we are close, I really am appreciative of the community raising these concerns, because that made me recheck the plans, and few of those things got picked up. So you will need some time to fix the drawings.
I believe I can still get this to you by the end of the week.
Sure.
Yep, they keep on the September, because after that I come into the holidays and I'm out basically for all the hearings in October. So I'd prefer to get this on the September hearing, just to have this also done.
I am going to look towards Mr. Costanza to tell me if there is room.
Yes, we're able to.
Okay. All right, so you have 1 week to submit. Please make it absolutely thorough, precise, and I know you do it, but just for the record, please do, and have responded to all the comments.
Just to recap the comments, if I may. So I have to update the EAS with the most updated plans that will change. Put a note about landscaping with details about the landscaping, how it'll survive with this design. Vinyl opaque fence to be shown between us and the neighbor with a wrought iron on the other side. Show the lighting, or add the note rather regarding the lighting, that it won't spill over to the residential neighbor, and put a note on the plans regarding the HVAC sound attenuation.
Yes.
Mr. Goldstein, I just wanted to confirm with Ms. Benke, if the project, the narrative, the project description in the EAS has to be modified.
It'll be modified. I'll take that. She mentioned I should modify it to the new plans, which we will.
Right. Thank you.
Sorry, Chair.
I'm sorry. I'm sorry to interrupt.
Go ahead, Ms. Prenga.
Can you also, I'm sorry, please disregard. Thank you.
Okay.
Yeah, Vice Chair, for the landscaping, I thought what you meant is modify the section view of that building to like make the landscaping visual on the cross section, and putting some sort of language that this part of the structure will be designed to withstand the landscaping, just not to be surprised later on that you want to do landscaping and the structure is not capable of receiving the loads from like the soil for the planting, or some sort of visual representation on the section view with some sort of language that the structure should be designed to withstand proposed landscaping. Am I correct, Vice Chair?
Yeah, I think we had done something like this with another house of worship, where a detailed section was provided of how in-ground planting was going to be accommodated over a cellar. So just provide that, and in your section, in your elevations, in your section especially, you can show it and show a detail of it. And then in your sections and elevations, show the fences and the fence side. The fence side, I think 5.7 is a little too short. You should make it 6 foot.
Okay.
Okay, so I think we are good. 1 week to submit. Let's make a motion to close. I mean, we have September. What is the September deadline for submission?
August 24th, I believe it is.
So you have,
I have till then. Great.
you're right. So don't rush. Just do a,
Makes my life easier. I appreciate it.
yeah. Okay, so till August 24th, you have to submit for September. So with
Yeah,
that-
August 24th, the submissions were 9, 12, and 13.
Yeah, okay.
Perfect.
Okay.
Okay,
And the motion.
motion to close?
Are you closing?
Yes, please.
A motion to close. Vice Chair Chanda,
Aye.
Commissioner Otley Brown,
Aye.
Commissioner Sheta,
Aye.
Commissioner Shabeta,
Aye.
Commissioner Yoon,
Abstain.
Okay, that's it. This concludes the public hearing for November. Wow.
Whoa.
August 8th, 2022.
Thank you
We'll
very much,
resume
everybody.
tomorrow at 10 a.m. for the next review session and hearing for August 9th.
Thank you very much. Have a good day, everybody.
Thank you. Yay.
Thank you, everybody.
Thank you,
Great
everyone.
job,
Thank you,
Vice
everybody.
Chair, Commissioners. Yay.
I think I'm going to stick to this format tomorrow.